Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
This is the next church on February 28, 2020. 7:44 p.m. How does the FBI find people? The people's misspelled P-E-O-O-P-L-E.
I object.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
What more do you need to see?
Alrighty, welcome back to the Court of Public Opinion. I am the Recovery Addict. We are getting set to join what could be the final day in the Lori Vallow trial in Arizona. She has one more trial after this. She's not done in court. This is just the last murder trial. She has some accused murder trial coming up as well. He's actually been I think he's been watching this one, so it's been interesting there. So we're just getting set. Let me see if I can bring you into that now. Wow, it's a mess. Holy cow. Let me fix my screen because it's doing all sorts of weird things. First of all, just turn off camera 1. There we go. Camera 4 is going to be media player 1. All right, we're getting everything fixed here. And when we do it will look absolutely beautiful. It'll be amazing. There we go. A little background there. All right, and I have no idea what we were counting on this trial. Does anyone remember what we were counting with Lori Vallow? Were we counting anything? Don't recall.
All right, we're on the record, State of Arizona versus Lori Daybell, CR 2021-001704. Why don't I have the state announce?
I think I have the state.
And the defendant?
Lori Daybell?
All right, we met on Thursday and went over jury instructions. In the meantime, since Thursday, there was a few modifications sent out. We
CW
put drafts on your desk this morning.
Congratulations, the internet is all yours, my friend. Good job, CW.
Last week, let me just pull up that email.
No eating reports, please.
Last week, the state requested some modifications that were made, and then on Friday, Advisory Council also requested a correction to the presumption of innocence, which I did do, as well as a mere presence instruction. Does anyone want to make a record on any of those changes that have occurred since we met Thursday? I forgot, I don't know if my staff told you, I did add, I realized standard number 9 was not added, which is defendant need not produce evidence, so I added that this morning as well.
Because she didn't.
Have you had a chance to review the latest draft, or do you need more time? We told the jurors to be here at 11, so we have time if you need more time.
We have bonus time we can cut into.
I think 5 and 6.
Yeah, the shackles are off, figuratively, for Lori when it comes to closings. She can probably go much further afield than she did in the opening, where she had to say the evidence will show, which I don't think the evidence showed pretty much anything that she that she said it would show. So the jury's probably a little disappointed and confused at this point. She is wearing a shock belt. That was one of the agreements. The only way this happens the way it does is she has the stun belt on that can deliver a healthy dose of reality.
Any other record you want to make on mere presence?
Oh, yeah.
All right. Has the defendant had a chance to review the final instructions?
Yes, Your Honor.
Any additions or corrections?
No, Your Honor.
All right, we're still waiting for a few jurors to show up. The plan this morning, well, let me ask the defendant, you still plan on resting?
I do.
Okay,
no
so when the
changes.
jury comes in, I'll remind them that the state rested last Wednesday, and then I'll turn to you and you'll presumably say the defense rests. I'll read the jury instructions and we will break after I read the jury instructions. Depending on what time we break, I'll tell them what time to come back for the closing arguments, approximately an hour later, or around 1 p.m. While we're waiting, I had my staff email the parties about any potential aggravators. I didn't see a response to that. So in addition to, if there is a second phase of this trial for aggravation, in addition to a dangerous finding, does the state know what other aggravators it might be pursuing?
Potentially the emotional harm to the next victim.
Anything else?
The presence of an accomplice.
Okay.
That should be it.
And in the event that happens, would you be producing testimony or evidence, or would it just be argument?
Potentially testimony from next victim.
Okay. All right. So, how many jurors? You can go ahead and print out.
Your Honor, I have two issues I'd like to bring up real quick.
Go ahead.
The jury process of the jury alternate selection, can you tell me what that process is going to be today?
It's literally drawing two numbers randomly out of a container.
Okay. And when is that going to be done and how does that
Not
work?
till after the closing arguments.
Shortly
Okay.
before the
So
guilty
the
verdict.
alternates are told that they're still alternates, they're not released, because I have had in the past jurors become sick or ill or not be able to deliberate, and we have to call back an alternate to deliberate. So they're still under the admonition until they're released.
So we're keeping all of them, basically.
But only 12 will go back and deliberate.
Okay.
If one of those 12 becomes sick or is unable to deliberate, we would bring in an alternate and release the person that can't deliberate. Does that make sense?
Yes.
All right, what else?
So it came to my attention this weekend that the exhibit number 286 that the state put into evidence, that Detective Inkland testified to was the full interview is only about 21 minutes long, and the actual interview is about 55 minutes long.
Remind me, what's 286? Is whose interview?
It's my interview, I guess, with Detective Inkland.
I think that's been redacted because the full interview wouldn't be admitted into evidence for the jury to review. Is that correct?
Correct.
All right.
So is it just the snippets that were played all together?
It should just be the parts that were played in court. Is that correct?
Yes, I mean, they're all connected. But
All right.
the state redacted out the beginning, the end discussions of hiring. That would be hearsay or not.
Right. So did you have a question about that?
Yes. So is it just the snippets all put together, or is it the interview for the first 21 minutes?
I think it's just the snippets that were played in court that are put together as one exhibit.
There's connectors between all of it, but it does not include any of the beginning or the end of the interview.
Right, portions have been redacted out.
Yes,
But it's just more or less what was played in during testimony.
correct.
Does that answer your question?
Kind of, but Detective Inkland testified that it was the full interview. So what does that mean if she's testified that it was the full interview?
I don't know. It's something you could have cross-examined her on, but now it's probably too late.
Oh.
If you wanted clarification on that. But the jury is going to know it's redacted, and they get the redacted exhibits instruction as part of the instructions, so either side can point that out to the jury that it's redacted. Anything else?
I was just assuming that that might have been an error to say that it was the full interview when it wasn't the full interview, and it was admitted into to reflect the record that it was the full interview. So are you telling me that the jury is not going to be able to go back and watch the full thing?
Your full interview?
Correct.
No, because it was never admitted into evidence.
But that's what they said was admitted into evidence.
I don't remember if that's what was said or not. I would be surprised if someone said your entire interview was being admitted, but I don't remember the exact
My advisory
testimony.
council checked the FTR, and that's exactly what was said. That was exactly what I was shown, that it said, is this the full interview? Yes, this is the full interview, and it was admitted into evidence.
Was there sometimes they enter in the full interview for appeal purposes only, but that's not the one that actually gets shown to the jury. Was that the case?
Was not for appellate purposes, Your Honor.
Okay.
It is the full interview. The defendant talks to the detective in the beginning about Kylie. It does not include that. She talks to the detective at the end about Kylie and victim services. It doesn't include any of that. She's sitting in a room for I don't know how long while Kylie's being interviewed. It doesn't include any of that. It is her interview about what happened.
Okay. So the states closed their evidence.
You could still move to have it.
I'm just trying to find out what the jury
jury
is going to be seeing. They have all that evidence in the evidence when they deliberate. Is that correct? They
Whatever
have
was,
access to that.
whatever was admitted into evidence, which portions of your interview were not admitted into evidence, it sounds like.
Okay, but from what I'm understanding from the state, just correct me if I'm wrong, it's
She won't
not
let
just
go.
the snippets that were played, but it's a partial part of the interview and some of it was redacted. Is that correct?
That's what I'm understanding. The parts regarding what Ty Lee said or did or didn't happen, the hearsay parts were, the start and the end were redacted out.
And then what was meant by the testimony that this is the full interview?
I don't know. I guess that's something that someone could have asked that witness.
in the moment when it was timely.
Maybe it was the full interview of your version of what happened.
So we have
There.
our Exhibit 20, the defense's proposed Exhibit 20, is the full interview. Can we replace that one with the full interview since it was entered into evidence as the full interview?
No.
Why not?
Your full interview won't come in because it's a significant amount of hearsay within that interview that's not admissible evidence.
It was admitted as the full interview.
Well, if a witness testified that it was a full interview, either side could have clarified that with that witness. I don't know what that witness meant when they said that.
She's trying. She won't let go.
Anything else?
That's it.
In this episode
All right,
of Lori
we're
Plays Lawyer,
getting the sufficient number of the
yet
jury
another
instructions copied. As soon as that's done and our jurors get here, we'll read those instructions. All right.
so she had an objection. Now this is interesting. First of all, her lawyer brought this up. Okay, so this was not something that she found on her own. Her standby counsel raised this and said, hey, a lawyer would have caught this. And since I'm a lawyer and I'm just hint, hint, this happened. If you were a lawyer, you would know that. But it's not timely now. Now, I don't think it's risen to it rises to the level where you would file a complaint against opposing counsel because the prosecution purposefully misled the jury by presenting it was an error that they overlooked. Okay, these things happen. It's a tiny one. The actual evidence was correct. How the witness described it might not have been accurate. Her trying to shoehorn the entire hearsay evidence, including Tylee's interview, into the witness view based on that. Okay, let me just, first of all, how many times are we going to have in her closing a reference to the evidence that you didn't get to see? Yeah. If you had been allowed to see the whole video, yeah. Objection. Yeah, it's going to be good. All right, the closings have not happened yet. We are waiting. We're going to have jury instructions first. Those jury instructions are going to spell out the law in this guilt phase of the trial. And when the judge says if we get to a penalty phase, what he means is if the jury returns a guilty verdict, the next phase of the trial with the same jury is the penalty phase, where they will continue deliberating, hearing evidence once again from the prosecution and defense. It can get confusing because it looks like court started over at the beginning sometimes. But oftentimes they'll say, we will submit all the prior evidence, all the testimony, all the physical evidence, plus a little bit that is admissible in the punishment phase that is not admissible in the guilt phase. So if we get a guilty verdict back, that's the next phase of the trial as it begins. And it will probably be a day or less. It'll probably be much shorter. Sometimes it can be just minutes. One or two people take the stand and that's it. We'll do objections on both sides. We'll count objections for both sides. That will be a great one. I'm predicting that we'll only get objections from the state that are sustained. So anything that Lori objects to during the state's closing is probably going to be overruled. There's also a good likelihood that the stuff that the state objects to in Lori's closing is overruled. Unless she's like talking about evidence that you should have seen but you didn't get. Things like that. Lynn Britton. Late, had to be replay, crew catch up. Thank you, RA. Always a fun time listening to cases with you. Thank you, Lynn. It's good to have you here. Is that Runkle of the Bailey I see in your profile picture? That looks a lot like Runkle to me. Lynn, that looks like Runkle. Congratulations on 17 months. Let's see. Can the DA talk about her children in the penalty phase? Not to the extent you might think. You can't also include the fact, and she was convicted for their murder. I don't think that can come in, but where they sort of preface and said one of the aggravating factors they might suggest is the emotional effect on a surviving victim or something like that. I think that was the words the state used. I didn't hear it quite clearly because the state didn't have their microphone turned on for this little part of court that we just watched. So that would be some way that it could be brought up briefly, but it's not going to be brought up. Oh, and by the way, they're dead, and she's found guilty of killing them, or for her role in that. Can you imagine? I mean, it's hard to imagine this for those of us that follow true crime in any degree, that someone out there has not heard of the Lori Vallow case and the kids. But can you imagine these jurors, these 12 jurors, who come back out of deliberation, finish sentencing this weird Lori Vallow lady who told us the evidence would show a lot of stuff and then never showed us anything. And they come out and they say, now that it's over, let me just do a quick Google search. Why have I not heard of this? Holy, she did what? Her? Yeah. It's going to be like an eye-opening experience. Oh, man. 80s Music Man, all you have to do is just wear the hoodie and remember that you have that instead of membership. We've tried. We don't know how. Apparently you're not, YouTube does not recognize your account or something. Okay. Verdict back within the hour, says Judy. It could be a quick one. In the last Judge Boyd trial and sentencing, his previous murder charge was brought in. Okay, I can see that. And priors would be important for sentencing. However, if you look at chronologically, can you punish someone for a crime they committed after this crime? Like, can you make the first crime, say they committed crimes A, B, and C. You try them and convict them for A, for B. And then you go back and try them for A. Can you use the B conviction, which happened after A, to say now we get a harsher penalty because she, her part in the killing of her children happened after this. They were alive during this part. So you're sort of turning back the time and saying, what did we know then? What applies now? Did you have any prior convictions at the time this crime was committed? Or do you say, hey, that's just not fair. Just because you tried them in reverse order, now she's getting a lighter sentence because we aren't allowed to retroactively look at things. We tried things backwards. Don't know. It'll be interesting to see to what extent they're allowed in. If she gets convicted on this, can they use this on her next trial? Probably for sentencing. Her next trial for sentencing, which is an attempted murder trial. But realize, she is going nowhere. I don't foresee in the Idaho trial that there is any appellate issue that is just glaringly so obvious that she gets a new trial and gets a life conviction without parole thrown out. Got some calls. Hang on.
Call from Ryan Apple Snapple.
Ryan, my friend, how are you doing?
Good. I'm at home today, so I'm not at the courthouse. But going off of the whole ABC thing, so the man who murdered my uncle back in the 90s in Arizona, in Maricopa County, so same county we're talking here, when he was available for parole and probation, they used everything he had done in his past before and nothing to do with my uncle's murder against him, so he did not get released. Now, in my heart, I felt he should be released because he has changed. He has done his, debt to society. He has grown. There's been growth. But the courts used everything against him that happened in this man's 20s back in 1994, 93, and 92 against him for getting out. No, death penalty was not a factor here. We do have the death penalty in Arizona in Maricopa County.
But it's not on for this one.
No.
Interesting. Yeah, for parole, that would everything. I mean, they can look at all sorts of stuff for parole.
Yeah.
In the sentencing phase, though, I don't know.
I don't
think
so.
I don't think they can bring up Tylee and JJ. Aside from the impact this had on them, the killing of conspiracy killing their father.
Correct. They didn't even use the body cam footage, though, of Charles when he was trying to get Lori petition. We have something called CBI out here. It's Community Bridges. It's our mental health facility. When he was trying to facilitate a petition to get her seen, and it's on body cam with Chandler PD, it was not used in this trial.
Interesting choices, what they decide to run with and what they don't. But
well, he's seen as hearsay because Charles couldn't be cross-examined.
Yeah, it's a little difficult to get him out. Travel arrangements for the dead are
pretty expensive.
We haven't had seances in court for years. It's been such a long time since that's been allowed.
Yeah.
Think Salem.
But I hope you had a good Easter. I hope everybody else had a good Easter. I missed all of your green chili chicken enchilada viewpoint. I was with my girlfriend, but
you did miss
I
out.
do want to try. I do want the punch recipe because her and I are both sober and it looked amazing. And we want to try it.
The idea, it's better if you get like a concentrate, like frozen, like cran raspberry. If you can find it like in the orange juice concentrate, if you can find that frozen, that's better. If you can't find it, then the ocean spray, just ready to drink, is okay, but it sort of changes the mix. So you use a little bit of that, and then you want to add the sparkling grape and sparkling soda water or something. So it's got a lot of bite to it as far as the carbonation goes. But
it was the ginger ale, correct?
It wasn't ginger ale in hers. That was in mine, and that was a bad choice. The ginger ale does not mix well with anything. I take that back. So that was something I thought would be good with it, and it was not. So,
I thought it would be.
She does also put whole raspberries. So you wash raspberries and put them in. I recommend freezing them, so then they're like ice cubes. And it keeps your drink cold, and then you can eat them once your drink's gone. It's delicious. So,
but is it 1 part to 1 part to 1 part with the liquid?
Yeah, pretty much.
Your heart.
Let's see. I think you add 1 cup of the concentrate, like half a frozen container of the juice, and then it's 1 to 1. So you're adding 2 liters of liquid to half a cup of concentrate.
Okay.
So.
All right.
Yep.
And then just so you guys know, when the camera kind of shakes, the door to the courthouse is right next to the room where the camera is, because the camera is in kind of a cry room that you would see in a church.
Right. It's in the quiet room through the smoke-filled glass. You can film through it. Yeah.
It's in the quiet cry room, whatever you want to call it. I mean,
here it is. Here's the recipe. Mrs. R.A. just chimed in with the actual 1 can frozen cran raspberry, 1 liter club soda, 750 milliliter sparkling grape. That was it. The sparkling grape.
Thank you, Miss R.A. I screenshotted that. I appreciate you.
Awesome.
But I hope everybody has a good day.
Thanks, Ryan. Appreciate it.
I'm glad I can't be there. I was there today.
It's a bummer. All right.
But I heard people were up at 5:30 this morning.
Wow, that's early. I was asleep.
My friend got there at 5:45, and she said there were already people in line.
Yeah. This might be the last day. So, slim chance it goes till tomorrow. Could happen. So.
The only thing I see it happening is running over to tomorrow, because they take lunch at 12 o'clock our time to 1:30, and then they close at the night for 4 to 5 o'clock. So that's where we can run into issues. But
if the jury sits in the jury box and they do a straw poll and they're all guilty and they're like, okay, we have nothing to decide, and they come back with, that's the only way it's going to end tonight. Is that what you're saying? Because it's going to be, I think we'll just get to deliberation tonight.
I think it's going to be an hour or 2 of deliberation. But the problem is just the time constraint on the day, because it's 11:27 here now. 12 o'clock they take lunch. If they take lunch, actually do to 1:30, and then 4 o'clock we wrap up. Like, they already said an hour and a half just for prosecuting close-up. So
it's going to be fun. I'm here for it. We're here all day. Tomorrow it's Karen Reed, but today it's Lori Vallow. Ryan, thank you very much for the call. I appreciate it.
Yeah. Take care, everybody.
We'll
thank you, Miss R.A., for the recipe.
Okay. Ryan's great. Nikki Zeebs, member for 24 months, OG. Says, yeah, I'm finally pink. This has been the best 24 months. All right. Thank you so much for everything you do for us to make this community the best. Thank you, Nikki. It would not be the same without you here. Appreciate you as well. Congratulations there. And look at this. Winnaboo, 14 months. All right. Love the cooking show. You, Mrs. R.A., make a great team. I laughed so much. I needed that. Please, more cooking shows. I will be trying it. Love hot food. Okay. I've already told Mrs. R.A. that the next one I want to do is something I know how to do well, and that is a fresh garden salsa. But we might have to wait just a little bit until like fresh food is available. So it's still a little early to get some of the peppers we want, some of the Roma tomatoes. I'm going to go all out. We're going to make a gallon of fresh garden salsa. And it's incredible. It's really, really good. I make it different every time, but so there's no recipe to follow. I actually am following the recipe that a guy named Todd Christensen, I'm going to out him. He was one of the foremen when I worked at a metal building company. He was the shipping foreman, and he made this for like a company party one time. He brought it, and it was so good. And oh man, it was fire. He used a lot of habanero in it. It was so good though. It was worth the pain. And anyway, so he gave me the recipe, but he always says I just sort of do it to taste, and I've never really had a fixed recipe on it. That's going to be the next one. Lots of chopping, dicing, and blending on that one, but not too much, because you're not making a puree. You're making a chunky garden salsa. All right. Should have had more for lunch. I'm still hungry. A gallon of salsa, yes. A gallon of salsa. So we're talking 18 Romas or so. Is about the 18 Roma tomatoes. Whole large white onion.
All right, that's fine.
Okay, we're back. No more food talk. Court's here.
All right, we're back on the record. State of Arizona versus Daybell, CR 2021-001704. The parties are present. The jury is not present. We'll bring in the jury.
This little delay was brought to us by the jury this time, with a couple jurors who had not yet shown up to court. They're here now. All rise for the jury. Pureed salsa is taco sauce. Yeah. Is Runkle tall in real life? I don't know. Lynn has met him. We have to find out from Lynn.
All right, please be seated. The jury is present. Welcome back, members of the jury. Last Wednesday afternoon, the state rested its case, so now I'll turn to the defendant.
The defense also rests, Your Honor.
All right, at this time, that concludes the evidence portion of the trial. I'm going to have my staff hand out to the jury the final jury instructions.
So we get to do a little read-along, or the jury does, as they will have their own copies, and the judge will be reading along with them. These instructions cover the different charges, specifically, or the elements of the charge that she's faced with, and the possibilities or the possible conclusions
Are
the
we
jury
one?
can reach.
Oh, nope, we got it. Okay. The jurors have the instructions. Much like the preliminary instructions, you can either follow along with me or just listen. I need to read these into the record. Duty of jury. It is your duty as a juror to decide the case by applying these jury instructions to the facts as you determine them. You must follow these jury instructions. They are the rules you should use to decide this case. It is your duty to determine what the facts are in the case by determining what actually happened. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and the exhibits introduced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel I have about the facts. You, as jurors, are the sole judges of what happened. You must consider all these instructions. Do not pick out one instruction or part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply together with the facts as you have determined them. Evidence to be considered. You are to determine what the facts in the case are from the evidence produced in court. If the court sustained an objection to a lawyer's question, you must disregard it and any answer given. Any testimony stricken from the court record must not be considered. Rulings of the court. Admission of evidence in court is governed by rules of law. I have applied those rules during the trial and resolved any issues concerning the admission of evidence. If an objection to a question was sustained, you must disregard the question and you must not guess what the answer to the question might have been. If an exhibit was offered into evidence and an objection to it was sustained, you must not consider that exhibit as evidence. If testimony was ordered stricken from the record, you must not consider that testimony for any purpose. If evidence was admitted for a limited purpose, you shall consider that evidence only for that limited purpose. Do not concern yourselves with the reasons for my rulings on the admission of evidence. Do not regard those rulings as any indication from me of the credibility or weight you should give to any evidence that has been admitted. Direct and circumstantial evidence. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise sensed an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence regardless of whether it is direct or circumstantial. Redacted exhibits. Some of the exhibits that have been admitted into evidence have had portions deleted from them for legal reasons. Do not concern yourselves with the reasons why some portions of the exhibits have been deleted. Do not speculate upon what the deleted portions might or might not reveal. Indictment is not evidence. The state has charged the defendant with a crime. A charge is not evidence against the defendant. You must not think a defendant is guilty just because of a charge. The defendant has pled not guilty. This plea of not guilty means that the state must prove each element of the charge beyond a reasonable doubt. Self-represented defendant. The defendant in this case represents herself. All instructions I read to you that include references to lawyers or attorneys apply equally to the defendant's self-representation at trial. The defendant's decision to represent herself should not be considered by you when determining the facts. Comments are not evidence. In their opening statements, the prosecutor and the defendant talk to you about the law and the evidence. In a few minutes, the prosecutor and defendant will give their closing arguments and will talk about the law and the evidence. What they said or say is not evidence because it is not sworn testimony, but it may help you to understand the law and the evidence. Credibility of witnesses. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says or part of it or none of it. In evaluating testimony, you should use the tests for truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness had any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before trial or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in the light of reason, common sense, and experience. Testimony of law enforcement officers. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. You are to consider the testimony of a police officer just as you would the testimony of any other witness. Expert witness. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it, in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. Defendant need not produce evidence. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce evidence is not evidence of guilt. Defendant need not testify. The state must prove guilt beyond a reasonable doubt based on the evidence. You must not conclude that the defendant is likely to be guilty because the defendant did not testify. The defendant is not required to testify. The decision on whether or not to testify is left to the defendant. You must not let this choice affect your deliberations in any way. Mere presence.
He's a fast
Guilt
reader.
cannot be established by the defendant's mere presence at a crime scene, mere association with another person at a crime scene, or mere knowledge that a crime is being committed. The fact that the defendant may have been present or knew that a crime was being committed does not in and of itself make the defendant guilty of the crime charged. One who is merely present is a passive observer who lacked criminal intent and did not participate in the crime. Voluntariness of defendant's statements. You must not consider any statements made by the defendant to a law enforcement officer unless you determine beyond a reasonable doubt that the defendant made the statements voluntarily. A defendant's statement was not voluntary if it resulted from the defendant's will being overcome by a law enforcement officer's use of any sort of violence, coercion, or threats, or by any direct or implied promise, however slight. You must give such weight to the defendant's statement as you feel it deserves under all the circumstances. Jury not to consider penalty. You must decide whether a defendant is guilty or not guilty by determining what the facts in the case are and applying these jury instructions. You must not consider the possible punishment when deciding on guilt. Punishment is left to the judge. Presumption of innocence, burden of proof. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means the state must prove each element of each charge beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find her guilty. If, on the other hand, you think there is a real possibility that she is not guilty, you must give her the benefit of the doubt and find her not guilty. Evidence of any kind. The state must prove guilt beyond a reasonable doubt on the evidence. The defendant is not required to produce evidence of any kind. The decision on whether to produce evidence is left to the defendant. The defendant's decision not to produce any evidence is not evidence of guilt. Voluntary act. Before you may convict the defendant of the charged crime, you must find that the state proved beyond a reasonable doubt that the defendant committed a voluntary act. A voluntary act means a bodily movement performed consciously and as a result of effort and determination. You must consider all the evidence in deciding whether the defendant committed the act voluntarily. Absence of other participant. The only matter for you to determine is whether the state has proved the defendant guilty beyond a reasonable doubt. The defendant's guilt or innocence is not affected by the fact that another person or persons might have participated or cooperated in the crime and is not on trial now. You should not guess about the reason any other person is absent from the courtroom. Motive. The state need not prove motive, but you may consider motive or lack of motive in reaching your verdict. The charged offense. I will now tell you about the crime with which the defendant is charged. Count 1, conspiracy to commit first-degree murder. The crime of conspiracy to commit first-degree murder requires proof that the defendant, on or about July 11, 2019, with the intent to promote or aid in the commission of first-degree murder, agreed with Alexander Cox that at least one of them or another would engage in conduct constituting the offense of first-degree murder. The crime of first-degree premeditated murder requires proof that a person, 1, caused the death of another person, and 2, intended or knew that he or she would cause the death of another person, and 3, acted with premeditation. Premeditation means that the defendant intended to kill another human being or knew she or a co-conspirator would kill another human being, and that after forming that intent or knowledge, reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. An act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. The time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. Elements of conspiracy. The crime of conspiracy to commit first-degree murder requires proof. 1, the defendant agreed with one or more persons that one of them or another person would engage in certain conduct, and 2, the defendant intended to promote or assist in the commission of such conduct, and 3, the intended conduct would constitute the crime of first-degree murder, and the defendant knew that such conduct was a crime. Scope of proof of conspiracy. To prove a conspiracy, it is not necessary to show a formal meeting or an express agreement. A conspiracy may be inferred from circumstances showing a common criminal objective and does not require proof that all means set forth in the charging document were agreed upon or actually used, nor that every person involved was a member of the conspiracy. Proof of membership in conspiracy. One may become a member of a conspiracy without full knowledge of all the details of the conspiracy. On the other hand, a person who has no knowledge of a conspiracy but happens to act in a way that furthers some object of the conspiracy does not thereby become a conspirator. Before you find that a defendant or any other person was a member of a conspiracy, the evidence must show beyond a reasonable doubt that the conspiracy was knowingly formed and that the defendant or another person knowingly participated in the unlawful plan with the intent to promote or assist the carrying out of the conspiracy. One who knowingly joins an existing conspiracy is as responsible as an originator or instigator of the conspiracy. A person understanding the unlawful character of a plan who knowingly encourages, advises, or assists in the undertaking thereby also becomes a conspirator. In determining whether a conspiracy exists, you should consider the actions and statements of all the alleged participants. However, in determining whether a particular defendant was a member of the conspiracy, you should consider only that person's acts and statements. A person cannot be bound by the acts or statements of other participants until it is established that a conspiracy existed and that person was one of its members. Justification for self-defense physical force. A person is justified in using or threatening deadly physical force in self-defense if the following two conditions existed. One, a reasonable person in the situation would have believed that deadly physical force was immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful deadly physical force. And two, the person used or threatened no more deadly physical force than would have appeared necessary to a reasonable person in the situation. A person may use deadly physical force in self-defense only to protect against another's use or apparent attempted or threatened use of deadly physical force. Self-defense justifies the use or threat of deadly physical force only while the apparent danger continues, and it ends when the apparent danger ends. The force used may not be greater than reasonably necessary to defend against the apparent danger. The use of deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate deadly physical danger appeared to be present. Actual danger is not necessary to justify the use of deadly physical force in self-defense. You must decide whether a reasonable person in a similar situation would believe that deadly physical force was immediately necessary to protect against another's use, attempted use, threatened use, apparent attempted use, apparent threatened use of unlawful deadly physical force. You must measure the person's belief against what a reasonable person in the situation would have believed. A person has no duty to retreat before threatening or using deadly physical force in self-defense if the person, 1, had a legal right to be in the place where the use or threatened deadly physical force in self-defense occurred, and 2, was not engaged in any unlawful act at the time when the use or threatened deadly physical force in self-defense occurred. If evidence was presented that raised this justification defense for count 1, conspiracy to commit first-degree murder, then the state has the burden of proving beyond a reasonable doubt that the defendant or co-conspirator did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Justification for defense of a third person. A person is justified in using or threatening physical force in defense of a third person if the following two conditions existed. 1, a reasonable person in the situation would have believed that physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person, and 2, the defendant used or threatened no more physical force than would have appeared necessary to a reasonable person in the situation. A defendant may use deadly physical force in defense of a third person only to protect against another's use, attempted use, apparent attempted use, threatened use of deadly physical force. Defense of a third person justifies the use of or threat of physical force or deadly physical force only while the danger continues, and it ends when the danger ends. The force used may not be greater than reasonably necessary to defend against the danger. Actual danger is not necessary to justify the use of physical force or deadly physical force in defense of a third person. The use of physical force or deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate physical danger appeared to be present. You must decide whether a reasonable person in a similar situation would believe that 1, Physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person, or 2, deadly physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person. You must measure the person's belief against what a reasonable person in the situation would have believed. The state has the burden of proving beyond a reasonable doubt that the person did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Use of force in crime prevention. A person was justified in threatening or using physical force and or deadly physical force against another if and to the extent the person reasonably believed that physical force or deadly physical force was immediately necessary to prevent another from committing or apparently committing the crime of aggravated assault. There is no duty to retreat before threatening or using deadly physical force. There is no requirement that any threat to the person's safety exists before the person may use physical force and or deadly physical force. However, physical force and or deadly physical force can be used only to the extent it appears reasonably and immediately necessary to prevent commission of the crime of aggravated assault. The person's use or threatened use of physical or deadly force is not limited to a person's home, residence, place of business, land the person owns or leases, or conveyance of any kind, but includes any place in this state where a person has a right to be. The person is presumed to have acted reasonably if the defendant reasonably believed he or she was acting to prevent the imminent or actual commission of aggravated assault. The person is justified in using physical force and or deadly physical force against another person, even if that person is not actually committing or attempting to commit the crime, if the person reasonably believed he or she was preventing the commission of the crime. Actual danger is not necessary to justify the use of physical force or deadly physical force in crime prevention. If evidence was presented that raised this justification defense for first-degree murder, then the state has the burden of proving beyond a reasonable doubt that the person did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Non-justification for threat or use of physical force. A person is not justified in using or threatening physical force against another in response to verbal provocation alone, or if the defendant or co-conspirator provoked the other person's use or attempted use of unlawful physical force, unless 1, the defendant or co-conspirator withdrew from the encounter or clearly communicated to the other person the intent to withdraw with the reasonable belief that the defendant could not safely withdraw, and 2, the other person continued or attempted to use unlawful physical force against the defendant or co-conspirator. The state has the burden of proving beyond a reasonable doubt that the defendant and or co-conspirator did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Definitions. Intentionally or with the intent to means that a person's objective is to cause that result or to engage in that conduct. Intent may be inferred from all the facts and circumstances disclosed by the evidence. It need not be established exclusively by direct sensory proof. The existence of intent is one of the questions of fact for your determination. Knowingly, willfully, or knew means that a person is aware or believes that his or her conduct is of that nature or that the circumstance exists. It does not require any knowledge of the unlawfulness of the act or omission. If the state is required to prove that the defendant acted knowingly, that requirement is satisfied if the state proves that the defendant acted intentionally. A defendant is criminally accountable for the conduct of another if the defendant is an accomplice of such other person in the commission of the offense, including any offense that is a natural and probable or reasonably foreseeable consequence of the offense for which the person was an accomplice. Accomplice means a person who, with the intent to promote or facilitate the commission of the offense, does any of the following. 1, solicits or commands another person to commit the offense, or 2, aids, counsels, agrees to aid, or attempts to aid another person in planning or committing the offense, or 3, provides means or opportunity to another person to commit the offense. Act means a bodily movement. Aggravated assault means a person intentionally, knowingly, or recklessly caused a physical injury to another person or intentionally put another person in reasonable apprehension of imminent physical injury by either 1, causing serious physical injury to another person, or 2, using a deadly weapon or dangerous instrument. Conduct means an act or omission and its accompanying culpable mental state. Deadly weapon means anything designed for lethal use, including a firearm. Dangerous instrument means anything that is readily capable of causing death or serious physical injury under the circumstances in which it is used, attempted to be used, or threatened to be used. Deadly physical force means either 1, force which is used with the purpose of causing death or serious physical injury, or 2, force which in the manner of its use is capable of creating a substantial risk of causing death or serious physical injury. Unlawful means contrary to law, or where the context so requires, not permitted by law. Jury foreperson. The case will soon be submitted to you for your decision. When you go to the jury room, you will choose a foreperson. The role of jury foreperson is important, but please remember that the foreperson's opinion about the case is not more important than that of the other jurors. The opinions of each juror count equally. The jury foreperson's responsibilities include the following. 1, make sure every member of the jury is present during all discussions and deliberations. 2, make sure that the deliberations are conducted respectfully and that all issues are fully discussed. The discussions should be open and free so that every juror may participate. 3, all jurors should be allowed to state their views about the case and what they think the verdict should be and why. 4, all members must agree unanimously on any verdict. Therefore, the foreperson should count the votes to ensure that every juror has voted. 5, if you reach a verdict, fill out the verdict form and then sign the form on behalf of the jury. 6, if the jury reaches a verdict, the foreperson will inform the courtroom assistant. When the jury returns to the courtroom, the foreperson will bring the signed or unsigned verdict form as well as any question forms that may have been used. 7, when you return to the courtroom, the court will ask the foreperson whether the jury has reached any verdict. The foreperson will respond yes or no. The foreperson is not expected to read any verdict to the court. That will be done by the clerk. Closing instruction. In a few minutes, we're probably going to take a lunch break, and then after the lunch break, you will hear the closing arguments in this case. After that, the case will be submitted to you for decision. I suggest that you discuss and then set your deliberation schedule. You are in charge of your schedule and may set and vary it by agreement and the approval of the court. After you have decided on a schedule, please advise the courtroom assistant. You are to discuss the case and deliberate only when all jurors are together in the jury room. You are not to discuss the case with each other or anyone else during breaks or recesses. The admonition I have given you during the trial remains in effect when all of you are not in the jury room deliberating. After setting your schedule, I suggest that you next review the jury instructions and verdict form. It may be helpful for you to discuss the instructions and verdict form to make sure that you understand them. Again, during your deliberations, you must follow the instructions and refer to them to answer any questions about applicable law, procedure, and definitions. Should any of you or the jury as a whole have a question for me during your deliberations or wish to communicate with me on any other matter, please utilize the jury question form that we will provide you. Your question or message must be communicated to me in writing and must be signed by you or the foreperson. I will consider your question or note and consult with counsel before answering it in writing. I will answer it as quickly as possible. Remember that you are not to tell anyone, including me, how you stand numerically or otherwise until after you have reached a verdict or have been discharged. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or social media to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. All 12 of you must agree on the verdict. You must be unanimous. Once all 12 agree on a verdict, only the foreperson needs sign the verdict form on the line marked jury foreperson. You will be given one form of verdict. The verdict form reads as follows, and there is no significance to the order in which the options of guilty or not guilty are listed on the verdict form. So this is a sample verdict form at the end of your instructions. It indicates this is a sample. An official verdict form will be given to you by the courtroom assistant in the jury room. Verdict, count 1, conspiracy to commit first-degree murder.
A courtroom
We,
assistant
the jury,
in
duly
the jury
impaneled
room?
and sworn in the above entitled action and upon our oaths, do find the defendant, Lori Daybell, as to the crime of conspiracy to commit first-degree murder occurring on or about July 11, 2019 as follows. Check only 1, and the options are not guilty or guilty. In order to break up the closing arguments as little as possible, we're going to take our lunch recess a little early and start a little early with those closing arguments after you recess. So we'll go ahead and recess for your lunch break. If we could have everyone ready to go in the jury room at 12:45, please remember the admonition.
All rise for the jury.
Jury's going to go out. We're going to see if there's any business they want to conduct with the jury out of their presence, just briefly. We already had a tiny bit of that before, but hold tight. There might be, Lori might have another little special thing for us here. Let's see what happens. I'm not hearing anything. Nada. All right. Don't think they're going to, I don't know how long it takes for the jury to leave, but I think they're just going to lunch. I know they just began. I know in Arizona, the jury literally just got up and just dragged themselves out of bed into the courthouse, but we're taking an early lunch. What to do when they take a lunch? That's the question. It's a very, very early lunch. That means we've got another hour and 15. Let's see here.
Or
Defense 20.
No, it's defense 20.
It's defense.
Well, it's
They're
got
still talking about the same video?
Oh, It's going to be 200 and something. okay. Yeah, give me a second. I'll figure that out.
Apparently they're still talking about the same
And
video.
should we put it on a CD?
Anywhere from 256 to 272. You'll have to figure out which one it is. But we'll.
Andrew C., 24 months.
we can
Congratulations.
Might have to look at the actual exhibits to determine which one it is.
Fun fact, I had a hot pink
Yeah.
wheelchair when I
Ladies
was a
and gentlemen,
child.
we're going to ask that you take all of your belongings with you for lunch.
Anything else?
That's all, Your Honor.
So,
Remind me to clarify which one it is when we get back from lunch, but your staff can look at or your team can look at the
yeah,
exhibits.
Okay, so what just happened there? Lori just requested to have that same exhibit, that interview. I believe she requested the entire thing to be submitted for appellate purposes, not for consideration by the jury. So the entire interview submitted into evidence for appellate reasons, and it sounds like the state did not object to that. So it looks like that's gonna go forward.
kind of all eyes out here at the courthouse as we wait and see.
Yep. We're all watching the courthouse. 4 p.m. closings. We have an hour and 15 minutes. What in the world? Let's see. What's camera 6 show? 4:15 Eastern time. What do you guys want for second lunch? First of all, we're going to close out this poll, which is pretty one-sided. I believe we've got one person so far, one person who voted in the negative category as did the state prove, is she guilty of conspiracy to commit first-degree murder? The charge that she's facing right now, if we go over the elements, if you missed that, conspiracy to commit first-degree murder, right? That means she was in on it with somebody. And the elements of the charge are as such. One, that it caused the death. that on July 11th, 2019, she had the intent to promote murder with, the intent was with Alex Cox, who's dead now, but that was the intent. And the intent was to cause the death, intended or knew it would cause the death, and acted with premeditation. That premeditation is that little bit of time it takes to reflect and think about it and say, I wonder if this is a good idea. Spoiler alert, it's not. But that little moment of consideration is what separates the first-degree murder from second-degree murder. If there's no moment to think about it and premeditate, this would be a lighter charge. But she is charged with conspiracy on first degree, not conspiracy on second. They did read the instructions about self-defense, because Alex says he shot him in self-defense. So the jury does have to consider that as well as they weigh the facts and what happened. Let's see. The more votes that come in, the closer we get to having the results rounded up to an even 100. That's how it's going right now. We have 642 votes. 2% have said no, Lori is not guilty. Premeditation. Took car, took phone, took kids. Then there's the text when we got rid of him. Ned. All that. There's a lot. There's a lot of stuff there for the jury to consider. Don't they have to prove there was an agreement between her and Alex? If so, I don't think that aspect was proven. Psychosaurus Rex. They have to prove that on July 11th, 2019, the defendant acted with intent to promote murder with Alex Cox. Intent to promote murder. Caused that the action caused the death. It was intended or knew it would cause the death, and the action was done with premeditation. So that's, conspiracy side is the defendant agreed with another, the defendant promoted the course of action, and that such conduct would result in the murder, in an action that would be classified as first-degree murder. So I think you're right. The element where they have the text between Alex and Lori that says, hey, how about you pretend it was self-defense and just do him in at my house? That's not here. They don't have that. But I don't think that's a huge burden, because sometimes there could be some missing puzzle pieces that can be filled in with that circumstantial evidence. And I think there's enough of that there. One-hour break. If only they could see the text. Oh my goodness, there's so much. If only they could see. The funny thing, Lori wants the whole thing in, and several times during this case, the judge is like, no, I'm pretty sure you don't want that in. That's not a good look for you. So you might want to rethink that before you open that door. Got a call coming in from overseas.
Call from Angela.
Hello, Angela. Long time no talk. How are you doing?
I'm doing great. I was just really busy, so I was in the rewatch crew for the whole trial.
Oh, that's terrible.
I was first, the highlights only, but now, but later, but I'm actually calling. I think that she is guilty. That's without doubt. But I'm actually calling for another reason.
Yeah.
Finally, a case that you or / everyone else / others may be interested in landed in my backyard.
Okay.
I don't know if you heard about that U.S. student that was in Denmark for over spring break. He was arrested at the airport.
This sounds like a holdaway situation. What happened?
Oh, nothing much. Just he assaulted allegedly Uber driver.
Ooh. Was the fare too high? I mean, what was the?
I have no idea. But the hearing is on the 24th.
A U.S. Tourist assaulted an Uber driver?
Yep.
Guys, don't do
in
that.
Denmark.
Yeah, don't go on vacation and be mean to the people who you're visiting. You are a guest in their country. Okay, that's how vacations work when you go foreign. Unless you're a resident of that, you are a guest, and you should be on your best behavior, if for nothing else, to make the rest of us look okay. Make the rest of us think, now Angela thinks we're all like, what was his name? What's his name?
I don't remember what's his name, but I'm tempting to go over to Copenhagen and sit for the hearing. Unfortunately, I can't on the 24th because I have like some mandatory thing at a university. But whenever the hearing after that is, if I'm free, I'll be there. Trust me.
Would you save me a seat? I'm Googling right now. You said Copenhagen?
Yep.
Round trip.
Long time.
From PGV, that's my backdoor airplane.
Well,
to Copenhagen.
You don't have to.
Maybe direct flight.
Don't have to. You don't have. Well, one thing is you don't have to look for hotels at Copenhagen because you can stay here where I live. We have an extra house which is free since we don't have tenants, thankfully. And Copenhagen is just a train ride away, so like 40 minutes to train.
It costs the same amount to fly to Copenhagen as it does for me to fly back to see my family. $313 for a round trip to Copenhagen? This has got to be clickbait.
That sounds. It's a clickbait. No way.
Oh, connecting flights from 734. Now the price is going up when I actually asked to see the flights. Like, that is crazy. Oh.
I know that it's thousands of crowns, so.
1,300. 1,300 is the round trip.
Yep.
I don't know if the Uber driver assaulter is worth that for me, but I'm super excited that you might get a chance to watch that.
No, but I am like I said, the next hearing is on the 24th. I unfortunately can't, but whenever the hearing after that is, I'm really tempted to go over there.
Yeah.
That
would be awesome.
And the funny part is that he is complaining about the jails in Denmark. Is he joking or what? Google jails
I demand better treatment. I'm a tourist. I demand better treatment. I bet the Uber driver's like, I demand better customers. I shouldn't have to put up with this guy.
Seriously, look up jails in Denmark. It's like hotels, and I'm talking like high-end hotels. Like whole
do they make the
Scandinavia
little
is like
towel animals on your bed and everything, like on a cruise?
Okay, maybe not that high-end hotels, but maybe middle-end hotels. Like
they ring the bell for the buffet, and you all come down and you browse and eat what you like, all you can eat. I'm excited.
Yeah.
Well, I hope we don't. I know Pickles not politics. It always gets political when there's a U.S. citizen that's charged in a foreign country with a crime, and you guys, here's my take on this. When you travel to another country, it is your duty to be aware of the laws. It's your duty to understand the customs, the regulations, everything. So everything from getting permission to be there, from staying where you're supposed to stay, checking in if you're supposed to check in, all those things. I don't care if you don't do it in the country you're from. When you're in a guest country, you act as the way they have said, we will let you in if you do these things. And if you break the law, don't expect to get U.S. treatment in a foreign country. You're probably going to get treated better in Denmark, honestly. It's probably better in Denmark than if you've been in jail, say in Palm Beach or something. But yeah, frustrating.
Yeah, I mean, yeah, and there is also this thing called that. I don't know Denmark. I haven't driven in taxis in Denmark, but I have here in Sweden, and 99.999% of taxis have video surveillance, and it is very visible on all the taxis. It says like on the not maybe on the windshield, but one of the windows. It says this taxi has a video camera. So if there is a video camera, he's cooked.
Yeah, he's in trouble. What would the penalty be? Well, first of all, the attack, was it just a fight? Was there a death involved? That would be terrible if it was a death.
I don't know, but I know that he ended up in the hospital. So I don't know how bad the attack was. So serious injury was. But how the penalty was? Well, I need to say this. There was this very controversial, big. I don't know what's the right word to describe it, but there was this murder here in Malmö where I live, and we had this career day a few weeks back, and police actually talked about cases they covered, and among others, what penalties people got in those cases. And they covered that case because everyone heard about it. Seriously, like I don't know in what news it did not end up. Because how it happened and everything. And how old was the guy who committed the crime? The one that committed the crime that was under 18, he got 4 years in prison. And because he was under 18, he got in like juvenile detention or something like that. And the other guy, because there were two people, he got 15 years for murder.
Wow.
And that was like 6 people were arrested or involved. Arrested/involved. And the 15 years was like the highest they got.
Yep. Some countries, chewing gum is illegal. You just be aware. In most countries, murder is frowned upon. So just don't do that anywhere. That's as a general rule. That's my advice to y'all. So don't do it.
Yeah.
Angela, I'm excited. Keep us updated as you get to go and experience court in Denmark.
I will, and I will keep you updated regarding if I go there. You'll get the first-hand knowledge what's going on there, because apparently the line crime is not really because they reported it first. They reported just what he said and what he complained, but not everything. At least I don't think they reported everything. So, yeah.
Interesting stuff. Thank you, Angela. I've got another call coming in. I'll let you go. Good to hear from you again. Glad you're doing well.
Yes.
We'll see.
Bye-bye.
Bye.
Thank you. Bye-bye.
Call from Rebecca.
Hey, Rebecca. This is R.A. How are you doing?
I'm doing fine. How are you today?
Fabulous. Do you want to join me in a minute and right now and congratulate Courtney Arleo? I always get her name wrong. For 24 months of membership.
That's great.
Courtney, that's awesome.
Yes, I would happily. She's been there as long as I have. I haven't talked to you since Daryl Brooks.
Yeah, it's been a while.
So it's been a while. But I wanted to, and I have experience as a court reporter, and did some of that good schooling here. I never did get to 300 words a minute, but I tried.
That's so fast.
Anyway, I wanted to kind of clarify on they went over the instructions for the conspiracy for first degree and whatever. And there is a guilty option. Most people say guilty or innocent, and that's not actually true. It's guilty or not guilty. Not guilty means the state didn't prove its case. Right. That person may still be guilty, but, like in OJ, apparently the state did not prove its case. So it's not guilty or innocent like we usually think. It's guilty or not guilty.
Yeah. Very interesting. Very, very interesting. Yeah, a lot of people say, "Oh, they proved me innocent." No, they just didn't. They didn't have enough evidence to prove you guilty. So, good thoughts. I know in Scotland they have the not proven category, or used to. I think they might have done away with that, and we used to put that on some of the polls.
That would be more accurate, I would think. But just because they're not proven guilty in this trial, depending on the circumstances, they can either be retried or they can, say you're not guilty, not proven guilty, but you're not innocent either.
Yeah. Quite interesting. That is awesome. So how long has it been since you've done some court reporting? Are you still working on that, or?
I went from court reporting to TV captioning, and I did that for 5 years. And I retired about 15 years ago.
Is TV captioning easier?
Actually, it is for the part that I did. I did movies and pre-recorded shows, so I could stop the tape and go back.
Rewind, get it right.
Yeah. The ones I had the trouble with, we used to do the Tour de France, and that was hard because there were so many foreign words in there, and you're trying to keep up with the announcers and the views and things. Yeah. But TV live action is very hard to do, and I commend anyone who does that, whether they get them all right or not. And I don't see if there's any way that you can get them all done at 100%. But that's why they have scopists in courtrooms. The court reporter takes the notes and then goes and gives them to a scopist, who is a person who takes the untranslated information from the court reporting machine and puts it into English.
Huh. It's an amazing system, and somebody that's able to keep record in court like that perfectly. That is the official transcript. Everything that's done in court that reflects back and looks at the proceedings relies on that transcript. They don't go to the video and say, let's go back and watch the tape because court TV filmed it.
No, they don't.
No, it's like, show us the transcript. That's the entire appeals depends on that transcript. So important job, and
right.
Good on you that you were able to do that.
The highest level of court reporting that I've ever seen was a man who was the court reporter in the Supreme Court. And he, at one point in time, got up to 500 words per minute with 2 or 3 people speaking at the same time.
I don't know any keyboards that are designed to be used that aggressively. Think how fast you're typing.
But you're not typing on a regular typewriter. You're typing on a keyboard that has like 18 keys.
Yeah, but still, you've got to push. You're pushing a lot of keys at the same time, like multiple sounds, multiple buttons at the same time, which is different than the consecutive order that we have on our keyboards. But that's a lot of you're still pounding the keyboard.
Yeah, we have. You can have one stroke or one push down of all the keys with up to 10 fingers, and one stroke may say, "Ladies and gentlemen of the jury." So it doesn't just stand for one word at a time. You can put in phrases and lots of other things depending on what type of deposition or court proceeding you're.
Do you like set your own macros? Like I want all 10 buttons to mean that's it, I quit, or something like that. Can you customize it for yourself?
Yes, you set your own macros when you have your software, which you buy, and it's like $1,500 or something. You can set up your own macros. Then you can also, when I was in the Navy, I was a radioman a long time ago in the 60s. And when I was first learning, I couldn't figure out, there were a couple of keys I had trouble remembering. One of them was the letter L, which I now remember, and what it is, you go did-dot, did-dot, did-dot. It was did-dot, did-it, which means to hell with it. And so anytime you were in the middle of a sentence and you were 6 words behind and couldn't figure out, you could catch it by putting in the L. So anyway, I have a lot of experience in different things, but I've had a good life, and I will be 77 next week.
Well, congratulations and happy birthday in advance. Hopefully we get to sing to you on your birthday. So.
Oh, you will. I'll be on.
Excellent. We'll be watching Karen Reed during that part, unless,
barring
some
unforeseen
circumstance. So, Rebecca, thanks for calling.
I have one quick question.
Yeah.
Where did you hide all your Daryl Brooks sessions? I can't find them.
I deleted them. It's my one regret. When I first went to monetize my channel, because I wanted to do this for work, I wanted to do this to be my job, I got denied the first time, and they said for reused content. And I thought, I must have done something wrong with how I'm how I'm doing this, and I figured it was it wasn't. It was a video I had posted on TikTok and then also posted here that I owned, that I filmed myself. And so there's no undelete button, and I didn't save them anywhere else, so they're gone, unfortunately.
Oh, because, there are some, especially now because he got moved to South Dakota, there are people who can't, are starting to watch them again, and the ones I'm watching, they're not as good as you were.
It was a lot of fun. Those were some fun times. I do wish I still had those, but
yeah. But I will know now. I can quit looking for them. And again, you have a great weekend. I hope this jury comes back fast.
Yep. Thank you very much. Have a great day. We'll see you.
You're welcome. Bye-bye.
Got a call from Georgia during that. I'm not sure what that was about. It was a spam call. Never mind. I think. Yeah, it was a spam call. Never mind. I live and learn. Yes, I made mistakes. That's for sure. Best cycling phrase: chase patate, chasing potatoes. I guess I don't cycle enough. I don't know what that means. we need the L command. We need the L command here. Yeah. All right. We now have an hour. Well, an hour and 50 minutes until I think Josh sent something in. We might have one more quick watch here. Let's see what this is. This is Clayton County. It's not it. It's this one.
Very specific questions. I'm going to follow the law under the state of.
Okay, let's see if this is it. Clayton County Court. There she is. It was 1 month ago. Looking for the thumbnail. Josh, I can't find which one it is. There's a ton of them in here. I have to be able to search it up. You said 143. Okay, we might have something to watch here. Just 1 second. That's not it. I can't link to it. I have to be able to find it on Apple TV in order to play it. Total time was how long? .302 53. Okay. Find it. You're gonna find it. Josh, I'm looking. I'm hunting for this. 1 month ago, 302:54. Found it. Found it. Okay, 1 minute, 1 hour, 43 minutes. Okay, it took some time to get, but I think we're here.
2025, 10 a.m. calendar for, this is the civil motions calendar. And
Is this it, Josh?
first case on the calendar is Sally Anderson versus John Doe and Just Me and Rupert Law and
John Doe?
Ashwood Ridge Holdings.
We're ready for plaintiff, Your Honor.
All right.
Your Honor, Frank Bettinger for Ashwood Ridge. We are the only movant and the only defendant represented by counsel.
Okay. All right. Is there anyone here on behalf of Just Me and Rupert Law?
Just Me?
I don't believe they've ever made an appearance.
John Doe and Just Me in the same case? Yeah, 2 words, defend and.
All right. So this is for a tort premises liability case. And I'll go ahead and hear from the movant.
Yes, Your Honor. Again, Frank Bettinger for Ashwood Ridge. This is a very simple case. The plaintiff alleges that she slipped and fell and sustained injury in the common area of the apartment complex. She alleges that this was a hazardous area and the landlord should have done something to prevent her. The problem with her case and her claim is she used this exact same route to come to and from her apartment and the parking lot, which was her destination this day, for 8 years, weekly. And therefore, she, the plaintiff, had at least equal knowledge of any hazard, and we submit there was no hazard. But if there was, she used it all the time, repeatedly, for 8 years. She probably still uses it. I don't know that, but old habits die hard. And therefore, we think this is a simple case of equal knowledge, if not superior knowledge, of any hazard, and I'm not conceding there was a hazard, that the plaintiff felt.
Hazard ever reported?
Say again?
Was there a hazard ever reported?
She contends that she complained to the office before this happened, not so much about the hazard, but rather she was afraid that the pine trees might fall on her unit. She had an end unit apartment. But she doesn't know what she fell on, and I suggest that's because she simply wasn't watching where she was going.
Okay, and the lobby was interior, entirely interior?
Say again?
This was an interior lobby, not like a breezeway?
No, not at all. This is an area of open land, grass, if you will, trees, if you will, that was the border of the apartment complex. It was an area between her apartment building and the paved parking lot. It was natural. And it's the same way now, I do believe. And it was the same way from the first day she moved in 8 years before this incident. So she is traversing an area of the property with which she was intimately familiar. She used it all the time. It was her chosen path.
Were there designated walkways, like, you know, how people might take a shortcut over the grass, but were there cement pathways?
Charles Brown's thirsty.
There were, and she admitted that if she had gone straight out of her apartment to the asphalt pavement, she could have traveled along that pavement directly to her destination and never encountered any pine straw or pine cones or loose limbs, whatever it was that she claims caused her to fall. She says she slipped in her deposition and her one leg went one way and her one leg went backwards and she twisted her knee. But the important point here is that she was intimately familiar with this path. And if there was any danger, she assumed the risk week after week, month after month, year after year. And we don't think the law will allow her to suddenly recover from, if it was a hazard, and again, I'm not conceding that, a hazard of which she knew better than maybe anyone at the complex because it was right next to her unit.
Mr. Hendricks, slip and fall law is pretty concrete when it comes to the tenets of, equal knowledge and having access that would give you knowledge over and above what the landlord would have. In addition, in this case, there was a designated path for travel, but your client deviated from that path. What makes this a case where the court would find that there's a genuine issue of material fact?
Morning, Your Honor. It's Louis Hendricks for the plaintiff for the record. Your Honor, we don't agree with the way this is being presented at all. There's one picture attached to our brief, which is a joint exhibit, a picture produced by the defendant.
Exhibit.
It shows the front of the apartment. It's one of those places where it's a row of like 5 apartments, single story. Each of them will have a door at the back and a door at the front. She was not in an end unit, not that it's even relevant. But anyway, from that picture, you will see there's a corridor going down towards where she walked. That's at the front of every apartment, a continual place. And there's steps at the end of it. That's where she went. That was a place designated to walk. Corridor and the steps going down. And Your Honor, the fact that she may have gone there before. This is not a case of a static defect, not that kind of case at all. The way Mr. Bettinger is suggesting is that if you go to the grocery store and go buy the milk part all the time, and you have done it for 15 years, the fact that there is water now on the ground that you didn't see and the management knew about, he's going to say, well, you have been walking here every week for 15 years. He doesn't mention incidental hazard that was there that you didn't know about, that they knew about. In this case, what we have is unrebutted testimony from my client, the plaintiff, that when she told the manager that she had fallen, again, note, Your Honor, it's after she fell, she went and made a complaint. The manager told her that 2 other people had slipped and fell on the lawn also. So they knew about the sort of poor maintenance that led to all manner of hazards, like some round things acting like roller balls under her feet. And that's what she realized after she fell. Your Honor, we cited a case where at a gas station, a customer, the case is Flood, on page 5 of our brief, gas station, oil and gas, customers buying diesel fuel, and slipped and fell on oil. The Court of Appeal said, well, okay, she could have seen the oily nature of the gas station pavement and all that. But the problem with that was that the management knew that one of the pumps was leaking oil excessively. And that created a kind of different situation. And they found that that was not fit for summary judgment.
Was this,
sorry, Your Honor.
I'm sorry, I interrupt when a question hits me because I'll forget otherwise. Was this a situation that was occasioned by a sub lawn care, somebody doing work on the property, or was this generally, from the perspective of the plaintiff, a hazard that was caused because the landlord failed to maintain the premises?
Yes, on both counts, Your Honor. The Rupert defendant is, in fact, was the lawn care company. We think, we still can't verify. But because we could never verify through discovery exactly who was responsible to take care of the lawn, we cited cases in our brief that ultimately the landlord is responsible. That, we cited toward the end, the last part of the brief is talking about that the landlord can't be excused because an agent was responsible to take care of the lawn. So we're still saying this was during COVID, and probably they have excuses, so to speak. But Judge, the situation with the lawn had changed, and this was an area where the tenants were expected to walk. It is true that she could have come out the front. In that strip you'll see in the picture, cars are backed up right to the apartment front, and there's this big 4 or 5 feet wall corridor open, and that's where people would come out, step down, go into their cars, or they would walk down and go down those steps. That's where she was going. Now,
okay, and one more question. So
Yes,
you said, have we identified the actual, were those like just suggestions, or have we actually identified the alleged hazard or whatever she slipped on?
some buds, as she describes them, some of those trees that let go of some round, hard things. I don't know the name of the tree or anything, but she saw this after. When she was after she got up, now she saw exactly what happened to her, but she was just walking normal. Now, her point is that had they been doing the lawn care, she had lived there for years, but they had slacked off. Whether they decided to become slum landlords because she's a poor lady, disabled and all that, that's the kind of complex we have. They simply let it go, and she was just there. She didn't go outside every day like that. She didn't necessarily go where the testimony, the evidence, you will not find evidence that she walked in that direction across that place every week.
The evidence will not show that.
Because I don't see it. I don't recall it. But she knew it. She has gone there before. But again, Your Honor, it's not static. There's no excuse for the landlord not to clean up. They slacked off, and they knew, according to my client's testimony under oath, questioned by Mr. Bettinger, that the manager told her 2 other people had fallen before her. That's what she says. Now, that's not rebutted.
Hold on.
Your Honor, I hate to argue.
You can clean it up in a minute, Mr. Bettinger.
All right.
Hold on. Last question, Mr. Hendricks. So I have pecan trees near my driveway. And there are times when the pecan tree is shedding, and we'll have these little hard pecan. They're not very good. I don't know what brand this is because that's not the kind I like. But anyway, they'll be shedding onto my driveway. And if I walk out, if I'm not careful, could slip because of the debris from the tree. And it's a constant. Like even when my kids use the lawn blower and clear it up, 10 minutes later or an hour later or a day later, there's going to be more shedding. There's going to be more pecans on the ground. In this case,
we need a song.
You're stating that if this is the type of situation, because you're saying hard tree buds, so that could have been walnuts, pecans, any of those things. It could have been actual buds, plant buds.
A little bit of bud.
That the lawn, that the landlord has a duty to maintain that constant, even though just naturally it's going to happen. Like leaves, you blow all the leaves are going to come back.
The answer would be, Your Honor, the landlord was responsible to reasonably prepare the place. We're saying that what they did and failed to do, rather, was unreasonable. They slacked off on the maintenance and simply dropped the ball on that. And poor Miss Sally going out there, not aware of that and not aware how hazardous it would be. And not only that, Judge, taking her testimony, because she's the only one who testified about this, that she told the manager, Mr. Goins, no, I'm sorry, he told her, 2 other people. Now, they had every chance to rebut that. They never did. He never filed an affidavit denying that. What he says is she walked somewhere completely different. So what we have is a dispute in the facts here, Judge, because he's claiming she walked one way and she's saying she walked another way. So the evidence itself, despite brilliant argument from counsel, the actual affidavits, the depositions, you'll see big time conflict in what happened. And with your pecans thing, Your Honor, does it get to a point where it becomes unreasonable for the person in charge to clean who doesn't clean? Can it ever get to that point? like the gas station case in flood. Gas station will have leaks, yes, but can it ever be unreasonable? The Court of Appeal says yes. If you have a pump that's leaking inordinately amount of oil, diesel fuel on the floor, people are walking, they wouldn't expect that, and they slip, you can be liable. So this is similar, we believe, Your Honor.
Okay. All right. Mr. Bettinger, you had some rebuttal for the argument.
Yes, Your Honor. This is not a leaking oil pump analogy. This was a natural setting, just as God intended it to be. Trees drop pine straw, drop limbs, drop buds, drop whatever. And there were alternative paths that any tenant, including Miss Anderson, could have taken to get from point A to point B, her destination, without ever setting foot on that. She elected to take a shortcut repeatedly. She doesn't know what she fell on until after she fell, and this is proof that she wasn't looking where she was going. She wasn't looking at the ground to see, oh, I wonder if I should step here or not. She was going to meet her husband and her son in the parking lot. That's unrebutted. And the manager was never deposed by Mr. Barrington. We set up 2 depositions. I took the plaintiff. Mr. Goins was present in the room with me when we deposed Miss Anderson, and plaintiff's counsel declined the opportunity previously arranged to depose Mr. Goins. So I take strong exception to, after the fact, the plaintiff submits an affidavit saying this. I could have perhaps deposed Mr. Goins. I could have redeposed the plaintiff. This was out of the blue. And Mr. Goins, by his affidavit, testified he never talked to her in the office simply because COVID had just come down. We ask in the brief, this incident happened mid-May 2020. That's 2 months after the lockdown went into effect. And he's testified that, number one, nobody came into the office. The protocol was you knock on the door, someone from the office will come, open the door, stand a safe distance, take down your message or complaint, and then have someone get back in touch with telephone. Mr. Goins, in fact, was not even on the property. He was managing it from a different complex. The only interaction that he has testified to by affidavit is after this woman complained, he arranged to meet her out in front of her apartment, again, safe distance. To find out what happened, she told him an entirely different story of an entirely different path of travel, not to the parking lot, but to the dumpster, because she was taking her trash out. And again, she took a shortcut over a wooded knoll. Now, it doesn't matter to plaintiff's case which version is the truth, because either version has her assuming the risk of whatever problems she encountered by taking a shortcut. That was her choice. And defendant should not be responsible for that. Your pecan tree example in your own home is on point. I don't know what she tripped on, but what I do know is that she did not testify to anything in particular in her deposition. Mr. Barrington says she was walking normally. Well, she can't have it both ways. She can't elect to use this, walk normally, and not pay attention to where she's going or what she's stepping on, and then turn around and say, oh, it's someone else's fault. And again, this is not a gas station analogy where this happens one time. This is not a grocery store analogy where a woman trips on a grape and the grocery store says, oh, we checked every 15 minutes, it wasn't there. This is something that she knew of and freely chose as her path for 8 years. You cannot hide behind that level of familiarity and claim, oh, it's not my fault. And there is no evidence in the record that there was any slack off in maintenance because of COVID. That is argument from Mr. Barrington. I don't begrudge him making argument. I'm making argument that she didn't see what she slipped on because she wasn't looking where she was going. But there is no evidence in the record from anyone. The landscape entity sued by the plaintiff was never served that I'm aware of. And they certainly never appeared, and no one took testimony from them. So I think it is speculation that they had slacked off. One of the areas of our economy that was able to keep going during COVID were the people who worked 20 feet away from everyone else. I would argue that the landscaping carried on because that's the safest place to be, in the wide open, fresh air, by yourself, picking up limbs or leaves or whatever. But there is no evidence of any slack off here. This is plain and simple superior knowledge by the claimant, assumption of the risk, and under Georgia law, she must show that the landlord had at least equal knowledge, and she cannot. She had superior knowledge. We argue at a minimum, she had equal knowledge of any hazard because this was a path she used regularly, and not just for a few weeks, 8 years. We believe summary judgment is appropriate under these facts.
So for both of you, you're all well versed in the cases that involve the summary judgment. Slip and fall cases and summary judgment with respect to slip and fall cases. And so, having heard your argument, I'll take another look at the written documents, the affidavits, and I've made copious notes regarding your arguments, and I will direct my order in the way that the court would allow and permit. So you'll get an order from us as quickly as we can, so you will know whether we're going to trial or whether this case has come to an end. Okay?
Thank you, Your Honor.
Thank you, Your Honor.
Thank you all for your patience also.
No problem. You helped me. I owe you one. Thank you, Judge.
All right, gentlemen. Thank you so much. You're free to go at this time.
Okay.
All right. The next case is.
Hang on. Wait, ma'am. Hold your horses. I'm trying to get my my song going. We've got a Jamaican song ready. It's not the best, but it's all I could do in the moment. So give me a second here. Suno. Sign in. All right, where's my library? I figured it would only be appropriate to have a Jamaican song.
A widener?
Why is that working? I don't want that. Stop. What to... You there. Pause. Stop. There we go. Okay, here we go. We're just gonna do it. Here we go.
Living
Living in a place where boundaries sway, where warm breezes dance near the bay. But trouble came on a sunny day. A slip and a fall, now I must say. She slipped on a nut or a twig or a bone. Did the splits right there all alone. Called a Jamaican lawyer on the telephone. Now she's suing for justice, a battle full blown. Was it a pecan, maybe a pine? A walnut or straw from the needle line. A fallen limb caused her to align. Her legs in a twist like a warning sign. The lawyer stepping in sharp and slick. Files in hand ready to do the trick. Saying to the complex, it better be quick. Justice for the lady, stop playing slick. She slipped on a nut or a twig or a bone. Did the splits right there all alone. Called a Jamaican lawyer on the telephone. Now she's suing for justice, a battle full blown. Stands with fire in her eyes. She's telling the story, no time for lies. The jury leans and the tension flies. The truth crashes down like rain from the skies. She slipped on a nut or a twig or a bone. Did the splits right there all alone. Called a Jamaican lawyer on the telephone. Now she's suing for justice, a battle full blown.
There you go. It's the lawsuit in in a couple little verses.
Was it a pecan, maybe a pine? A walnut, a straw from the needle line. A fallen limb caused her to align. Her legs in a twist like a warning sign. The lawyer stepping in sharp and slick. Files in hand ready to do the trick. Saying to the complex, it better be quick. Justice for the lady, stop playing slick. She slipped on a nut or a twig or a bone. Did the splits right there all alone. Called a Jamaican lawyer on the telephone. Now she's suing for justice, a battle full blown. In court she stands with fire in her eyes. She's telling the story, no time for lies. The jury leans and the tension flies. The truth crashes down like rain from the skies.
There it is, rain from the skies. She slipped on a nut. Little twist there. There you go. Oh my goodness. All right. There's so much I wanted to put in there. You need to have the reference to COVID. You need to have, 8 years. She walked there for 8 years. Now she slipped and fell. Stories changing. There's so much good stuff there. I missed it. I was busy making the song. Did the case get thrown out? Did it get thrown out, or were you just going ahead with everything? Oh man. Let's see. It's a good song. Well, it's as good as AI gets. It's an incredibly complex case. It's about the complex. Yeah. Oh my goodness. How dare you? I have to go listen to that. I can't obviously I can't play that here, but I'll have to listen to it off air. Case we'll get back to you in 4 to 5 weeks. Well, it happened during COVID, so it's not like we're chomping at the bit to get this done. It's been a while. That wasn't even the case you were supposed to. I know. Where's the case? I told you I thought it was the wrong one. Where's the right one that I was supposed to play? Where did it go? You said an hour 43, right? Is it the same hearing? The minutes lined up. It was from a month ago, and it's the same length of time as the one you sent me, Josh. But anyway, we're about 15 minutes away from going back to court with the Lori Vallow case, where we expect closing arguments will begin. You got distracted by Pine. That's nuts. That was not the one Josh sent. Can we just give Josh control over the Stream Deck? We could. Honestly, the option is there. He would just have to know what the commands were, and I have to figure out a way that makes only he be able to do it. I can confirm organized chaos. Oh my goodness. One thing I love about warmer weather is playing with my kids and the dogs outside with the water hose, or the water hose. Since we only have one, we call it the water hose. When I came out from break, when we went to lunch just a few minutes ago, before Lori Vallow started, I I look down at our hardwood floors and I'm like, why are there wet footprints in the shape of my kids' feet all over the house? They have been having a water balloon fight. They've been doing all these things. I'm like, hey, remember, our renter's here. You're not supposed to be using the hose when he's there. You don't turn on they're like, we didn't. And so then I had the follow-up question. I had to say, so where did you get the water to play outside, to be, and they're dripping, soaking wet? From the kitchen sink. Was where they got the water. They carried it out. When Mrs. R.A. was looking for the jug to make her throat punch in, the reason it was missing is because they're playing with the water out in the yard from the kitchen sink. Yeah. So, yeah, there's water all over the place. We get back to Lori Vallow in just a little bit. I see what you did there with that typo. I was at my friend's husband's funeral a couple of weeks ago. Oh, I'm sorry. And we went to the crematorium to Bob Marley, One Love, Out to Two Little Birds. It was lovely. There was ska for the committal. That's cool. I could do a little Bob Marley wake. That's pretty good. Your kids really need to learn forensic countermeasures. Anyway, they were drenched, and then of course I went upstairs to the one working bathroom we have right now, and they took turns running through the shower because they were cold now, because it's not that hot yet, and so once they showered, they left all their dripping wet clothes hanging over the sink, dripping down onto the new floor I just put in. So I had them fix that. Suno might do ska. There's a chance. I've not tried. I dialed it back. I only get to make 4 songs a day, and I just made 2, making that one. It's Getting Hot in Here is not recommended for crematoria. Who sings that one? Yeah. Have you tried cream of mushroom chicken? Yes, but I don't like the mushrooms. I prefer cream of chicken. Okay, so we're gonna be going back. Let me actually get ready so we don't miss anything. Going back to Lori Vallow in Arizona. Okay, that's all set. We've got about 14 minutes now before we begin. Why would you put floors in a bathroom that can't get wet? I can. They can get wet. I just don't like them to be wet when they don't need to. I mean, step out of the shower, the floor is going to get wet. It's going to happen, but don't get soaking wet and then come inside and just let it drip there and leave it. I'm going to listen to this, but I can't play it for you, unfortunately. Who made it? Let's see. Someone playing Minecraft. Oh, no, that's a different. This one is defaulted to something else. Let me find that. There we go. I fixed it. Can you remind us what you use for AI for the music? The app is called Suno. Akameku Cross. I don't know how to say your first name. It's called Suno. Suno. Mathis, who is frequently here on the channel, is much better at it than I am. He makes some real bangers. But the app allows for a couple free songs every day. But the Bolshevik Muppet, I hear you on that. You can't claim copyright on stuff like that. But tell that to YouTube, who will still enforce the strikes and count them against me. Derek Carney made it. Okay, I found it, but I'll have to mute my mic. Okay, I just listened to a little bit. It is good. It is really good. What app did he use to get everyone to sing? That's I'm curious. We are coming back at 4:15 Eastern Time, so just a few minutes. We'll be back in court, and we expect the closing arguments to be next on the docket. So they made for an excellent minute of content. It's pretty good. It's pretty good. So Lori just insisted that the video that does her no favors be put in its entirety into evidence for the appeal. Yes, but not for the jury to use. That's the important part. She thinks that something was wrong. So obviously her appeal is going to reference this video. So the judges that presumably will hear this appeal will be able to review it and say, yep, you're right. The judge made the wrong decision. Ari has, 4 or 5 screens, and still he has to use a phone as well for internet searches. The others are tied up. I had to play it so it doesn't go through the audio, so I just had to make sure it wouldn't accidentally go through. I use all my devices. Everything is utilized. Does anyone remember what the closing was like for Lori in Idaho? She had a lawyer then, right? She wasn't pro se then. They had avoided arguing Chad's involvement the whole time, but the lawyer went against her and argued it in closing. Oh, great. Do you think Lori will score points during her closing? I think it's going to be a rehash of the open. And I think she's going to fall into the trap where she's going to say, you should have heard. You should have heard this. You should have heard this.
Call from Gwyn. To accept, press 1.
Hello, this is RA. I missed the name.
Gwynny.
Gwynny, how are you doing?
Yeah. Not too bad. I just calling from Australia. It's still dark.
It's the middle of the night.
Been up for 2.5 hours. Yay for insomnia. I just wanted to call and say hi and thank you for everything you do.
You're most welcome. We love having a variety of accents. And the Australian accent is definitely underrepresented on the channel. So,
the last couple of times I've called, you've had regulars calling, so I'm like, nah.
Well, I saw this 6-1 area code, and I'm like, what country is that?
Yeah, Australia. Not Austria, which apparently there's a welcome desk in Austria, so in the major airport, saying this is not Australia. People go there with shorts and T-shirts and realise they're in the wrong country.
In what country do they fly to?
They fly to Austria.
Austria. That's a huge error.
Oh, it's only 2 letters.
That's like Alps and kangaroos.
Yeah.
There's your. I mean, you've got the Alps and the Outback. I don't know if you can get much more different than those two.
Yeah, packing for Australia summer and ending up in winter Austria, slightly different clothing needed.
Yeah. I wonder if there's a business opportunity there where it's like, hey, you screwed up, but, for this low fee, we'll get you some clothes so you don't freeze to death and get you some yodeling lessons or something. So.
But apparently there is a desk at like one of the major airports, and I could be mistaken, but this is what I have read, that it's a relatively common mistake people make.
That is crazy.
So, yeah.
That is crazy. All right.
We do have snowing. But yeah. But thank you very, very much. And yeah, I've really enjoyed everything. I'm a member, I have been for a little while, but I'm very inactive.
Well, it's all right.
And usually I'm very playful because it's either middle of the night.
You have to watch it all night long.
Working.
Yeah. We'll love it. Well, thank you very much. Thanks for calling and cheering us up a little bit with some Aussie accents. So.
Okay.
Right.
Have a good one.
You too. Bye.
Bye.
Love it. We're gonna be a tiny bit behind on the video. It's all right. We know that court starts and our feed has not, so it's all right. We know that they've begun. We understand. Ours are going to start in 5 minutes, so it's okay. We can do with a few minutes of delay. Let's see here. Let me do this one. Nope. We're going to jump down here. Take a look here. Let's take a look here. Not there. Let's go here. That's better. Okay. Oh, why can you guys not see me? 2, 8. Let's go to 8. All right, here we are. We're here now. We're gonna wait for the feed to start. We know that there are updates on Twitter that are a little ahead of our feed, but it's all right. Where can I find the Karen song, please? I looked it up on YouTube. It's by a channel named Derek Carney, DerekCarney, and it's called How Dare You? Karen Reed Anthem. How long are closing arguments? Like an hour and a half each. It's gonna take all afternoon. I can't see anybody moving. There's actually no action whatsoever in court. Of course, now they are. Where's the map located? The map is right here. There are 2 links. The first one is where you place your pin. Please don't give us your full address. We don't need that. I mean, if you send it to us, we might send you junk mail and stuff, but don't give us your full address. And then the second link is the one where you check to view other people. You can search their name and find where they are on the map. Motion to bring bed to court. Can I bring my bed to the court for this closing? I don't think you'll want it. You're going to be on the edge of your seat. Bring popcorn, if nothing else. Lori's not going to need nearly as much time. Well, when she sums up the evidence that she's presented, it's going to be pretty quick. Can you change your submission? I think so. Amber, can you fix it if Kaylee Rose changes her submission? Okay, video is going to start in just a moment. Thank you, Amber. Appreciate that. Assuming no jury members are late, we'll be underway in, I don't know, 15 seconds, 30 seconds, something like that. Can Lori testify in her closing argument? No, but she can make argument, which will give her a little latitude, actually. But I don't think it will give her as much as she wants to take, and that's where we're going to see the state object. So we can, in fact, get our objection counter ready. Let's see. Let's turn 3 off. Four is going to be camera 8. Nope, 4 is going to be camera 2. Okay, I think we're about ready. Box 2 is going to be camera 3, which we'll turn on. We'll turn this on as well. And take super source. Boom. There we go. Objection counter. Let me clean it up just a tiny bit. I see a shake. Looks like the door is being opened and closed. Let's go, says Judy M. We're waiting. We have closing arguments about to begin. The state gets to go first. Lori's going to give it a shot afterwards. I say this is Lori playing lawyer, and it's terrible to do this, especially on a murder case, your own murder case. Not recommended. This could go crazy. I've looked at this on Lori's portion. I think what the state's going to do is stick to the facts. Say, this is what happened. This is what she did. We proved each of these elements. It's done. I think they're going to stick to that. I think on Lori's side, we could get a crazy. Didn't she speak when she was sentenced in Idaho, and basically promised that God was going to destroy everyone that got in her way?
All right, we'll go on the record. State of Arizona versus Lori Daybell, CR 2021-001704. Before our break this morning, the defendant moved to have an exhibit admitted for appeal purposes only. That exhibit number, the correct number, I believe, is 269.
That's what I understand, Your Honor.
All right, so it's ordered that 269 would be admitted for appeal purposes. It won't go back to the jury during their deliberations. Go ahead and get the jury lined up, I guess.
Line them up. Tyrone Tucker took a plea, avoided the second trial. He got time served. He's done. He's out. He's been released. I will say that whether or not he was completely innocent of involvement in there, that's up for debate. But I think the city down there really did him dirty. I'll say that. Not a big fan of another, being pro se. I think he could have done better with a lawyer, but I think the city did him dirty there. If her vest gets activated, that might be the most rewatched clip on Twitter and TikTok and Facebook this year. Is it Ditat Deus? How do you say that in the middle on the top of the shield? I need to brush up on my Latin. Can we trigger it remotely if we all think hard? No, that doesn't work.
All right, the jury is now present. Please be seated. This is time set for closing arguments. The state can proceed with its closing argument.
July 18th of 2019, just 7 days after this defendant and her co-conspirator Alex Cox shot and killed Charles. This defendant texted her soon-to-be next husband, Chad Daybell, about Charles's life insurance policy. Her words tell us that she was involved in this killing. Her actions and her words of texting Chad Daybell tell us the motives behind this murder: Chad and money. The morning of that 18th of July, Lori Vallow texted Chad and said, quote, "I just got the letter from the insurance company saying that I am not the beneficiary. It's a spear through my heart. Who do you think he changed it to?" Later that day, after she spoke with the life insurance company, she sent Chad another text. Quote, "So I talked to the insurance company. He changed it in March. Probably it was Ned before we got rid of him." Lori Vallow's words 7 days after Charles was shot and killed tells us that we was her and Alex killing Charles. Why? For that money. But Lori Vallow's plan to kill Charles wasn't just known by her lover, Chad Daybell, and her accomplice and co-conspirator, Alex Cox. It was also known by her brother, Adam. Adam told us that he knew about Lori's beliefs. He knew what she had been saying about Charles's concerns for himself. And he told us that he knew about this plan for an intervention, to talk to a stakeholder. That morning of July 11th, when Charles arrived at Lori's house, as she knew he would, he texted Adam and said, "Al is here." Adam texted back, "They are planning something." He knew. And 3 days later, on Saturday, when Adam finally learned, when his friend Googled Charles, that he had been shot and killed by Alex, Adam told us he went back and talked to his mother, and he confronted her about this. And he told his mother, Lori and Alex conspired to kill Charles. He knew, and he was right. Lori's ex-friend, Christina Atwood, she told you about that very uncomfortable dinner on June 9th, a month before the murder, where Alex Cox was talking about just wanting to kill Charles. He said this multiple times, and this defendant didn't care. In fact, she talked about how she had been drugging Charles. Christina told you she was so disturbed by this, she actually went and saw Lori the next day, June 10th, and told her, if something happens to Charles, I'm going to have to go to the police. Christina knew. She was right. And Nancy Jo Hancock, now she had just met Charles a few days before, and they had talked and texted and had been on the phone for hours, you heard. Charles had told her all about Lori, the things she was saying, the things she was doing. She told you that she knew that Charles was concerned for his own safety. And she understood the motive. She told Charles the night before, you probably should just tell Lori that you've changed the beneficiary, that she's no longer going to get that money. Nancy Jo knew, and she was right. Lori Vallow wanted the $1 million, and she wanted Chad Daybell. And she and Alex used that twisted religious beliefs they had so that they could kill the evil, possessed Charles and be like Nephi. The evidence that has been presented in this trial will prove to you beyond a reasonable doubt that this defendant is guilty of conspiracy to commit first-degree murder. So I want to split up my closing into 3 sections. First, I'm going to talk to you about the timeline and the motives in this case, and the evidence that supports those. Second, I want to talk to you about the jury instructions and the evidence that's been presented to you in court. I'll remind you that anything the defendant said in her opening was not presented at trial through a witness or through an exhibit, and it is not evidence. Using the evidence that has been presented and admitted at trial, the state will show you how, again, the defendant is guilty beyond a reasonable doubt of this crime. And finally, I'm going to talk to you about those justification defenses, the excuses and the reasons why the defendant would like you to believe that they had a valid basis for shooting and killing Charles on July 11th. And we'll talk about how, in fact, there is no justification for what they happened. What happened that morning was a first-degree premeditated execution of Charles Vallow. So let's go through the evidence. The timeline really starts, and we know it goes back much further than this, but the big change occurs on June 29th or 30th, when you learned that Charles Vallow learned about these KK Walker emails. He learned about that affair with Chad. Now he knows Lori is cheating on him. We know that he contacted Chad Daybell about it. He contacted Chad's wife about this. He told Adam about it, and he told the defendant about it. So everyone knew that Charles now knew this. July 9th is now the first time that Charles is going to be coming back to Arizona. We know from the time he learned about that affair, he hadn't been back until this planned visit to see his son, JJ. We know at 1:13 p.m., Charles texts Adam and books him a flight for the next day. At 1:21, we know that Adam is contacting Alex. And they talk for 20 minutes. And Alex lets Adam know, sure, you can stay with me. Of course, Alex doesn't know the plan yet, the mission. Lori then starts talking to Chad Daybell. We know that she knows about this intervention. She knows about Adam coming, and we know this because, again, of her text messages. We see Lori then starting to round up the troops. Why does she do this? Because she wants to ensure that on July 11th, it is Charles and only Charles coming to the house and not the intervention of Adam or Brandon or Zach coming over to help him. So she has Melanie. Tells her she can't go to this wedding. She has to stay here. It's coming to a head. This week will change everything. Call me. Then we have July 9th, the text messages with Alex. She tells him, so the plot thickens, call me when you can. He doesn't call her initially. So she sends him another message. This one really letting him know. She specifically tells him, I'm going to need you to stay close to me the next couple days. Mel too, she can't go to Utah. She's got a job. They are planking some kind of intervention, but want Mel out of the way, so I'm left alone. She talks, I need to come get the stuff at your house tomorrow and secure it. Lots to do. Thank you for standing by me. It's all coming to a head this week. I will be like Nephi, I am told, and so will you. And then what happens? This gets Alex to call, and they talk for almost an hour. An hour planning how they're going to stop the intervention, how they're going to be like Nephi. As we get to the 10th of July, and we continue through this timeline, we see Lori again talking religiously with Chad, 149 minutes that morning. She's also texting Melanie Boudreau, Melanie B, telling her that it's important for the mission, for Melanie to help her by keeping Brandon distracted. And we saw those messages where Melanie says she'll pretend to be sick. We know that on the 10th, Adam arrives in Phoenix. And now we have Summer helping the defendant, letting her know what is going on with Adam and Zach. Everyone is covered to ensure that Charles will be alone on the 11th. We have the continuing talks with Chad, her soon-to-be husband. As we get into the 10th in the afternoon, we know that per their agreement, Adam calls his brother Alex. Hey, I'm here. Brother doesn't answer. He sends him a text. I'm here. No response. Why? Because the night before, his sister Lori told him, we have a mission. We must be like Nephi. Charles is coming into town. You must stay at my house the night of the 10th so you can be here the morning of the 11th. We also know that Summer gave Lori an out. Hey, you can stay at my house. No one will know where you are. We're going to be out of town. You can hang out here. Lori doesn't take her up on that. She has a mission to do. As the night grows on the 10th, Adam continues to try to reach his brother Alex. Again, no response. And by 45 or so minutes after that last text by Adam, we know Alex is already at Lori's house. He's there with his gun and a garbage bag of some underwear. Why? That gun is important. A loaded weapon, 2 extra magazines of ammunition with him. He is ready for his mission. And again, Summer is updating her, telling Lori that Zach and Adam are still at her house. They're going to go stay at Mimi's. And she even tells him that Adam is still waiting for Alex to get back to him. Still, he doesn't understand. Why isn't my brother responding to me? I was supposed to stay there. And again, what does Adam bring over? Gun and a garbage bag of clothes. That's all he needs to be part of the mission. When we get to July 11th, we still have Lori talking with Chad. We see those text messages going back between them.
Can we turn that mic off?
And then we start learning from the GPS from Charles Vallow's phone as he arrives. 7:35 a.m., he arrives at 5531 South Four Peaks. That's where we have at 7:36, Adam texting Charles. They are planning something. There is no reason why Alex should be there. And that explains why Alex wasn't responding to me and didn't let me stay there. We see that last outgoing text message by Charles Vallow at 7:37. And in fact, what we see is at 7:37 and 12 seconds, Charles sends out his last outgoing message. And at 7:37 and 29 seconds, there's an incoming message from Adam. It's not read until 12:13 p.m. What becomes important here is in this timeline, how long is Charles at the residence here? You hear in her interview how she says it's so fast. Charles comes inside. He's angry. He's jerky. And she tells him, take JJ. Go get him Burger King. They get JJ out to the car, and then she holds onto the phone. And this argument erupts, and it's just so fast. But what we know is it's actually 12 minutes long. This is not a fast incident. In this 12 minutes, Lori Vallow and her brother Alex Cox are doing their mission, and they are being like Nephi. We know at 7:49, it's over. Lori has left in Charles Vallow's car with his phone and JJ and Tylee. We know that there are 2 phone calls between Alex and this defendant after she leaves. As Charles is laying, dying or dead on the floor, 7:52, 8:06, they talk. 47 minutes passes before Alex calls 911. 47 minutes to stage the scene. The police are advised when they arrive that the shooting just occurred and that CPR was given. Why is that important? Because you heard even during the interviews, the police were trying to figure out this timeline. Didn't make sense. At 8:48, almost an hour later, Lori Vallow returns. And then we see that around 9:40, she is being interviewed at the Family Advocacy Center. We know that Lori Vallow has Charles's phone that entire afternoon. You saw the PowerPoint from Detective Werther showing that her phone by about 12:36 is already her phone, Alex's phone, and Charles's phone are all in the area of Alex's house out in Sandham. You see on her records that she, again, calls Chad Daybell. We see that Detective Enclan calls her and leaves her a message. They don't leave immediately because what do we know? We know at 2:13, Alex is taking photos of Adam's flight reservations from Charles's phone. Not screenshots, but photos of the phone. At 2:18, Lori Vallow, who has not told Charles's kids, his family, about his murder, is calling the mortuary. A little bit after that, they still haven't left. She's calling Chad again. And then by 3:11, we know that Charles's phone, through the GPS data, is back at 5531 South Four Peaks. And when asked about it, the defendant and Tylee hand it over and provide the PIN. They have no problem on how to get into it. They've already looked through it. They don't need it anymore. That evening, Lori and Chad are talking all night. You can look through the exhibits and see the multiple calls of them discussing. These aren't calls to Charles's family. They're not calls to his kids. They're talking with her lover, her soon-to-be husband, Chad Daybell. So let's talk about the motives of this case. Money. We see that from the text messages and the anger that you see through them when she learns that that's been changed and she's not going to get it. Chad Daybell. We didn't go through those text messages, but you can look at them. They are already very romantically involved by the time that Charles is murdered, And it's clear that Chad knows exactly what's going on because he's asking her about the car, about the insurance. All of those things Chad knows. And then there's that religious belief system. The zombies, the Z's, the possessed evil spirits. And her being like Nephi. All a reason and a way to kill someone, just like Nephi, a justified killing. There's that first call when we talk about money motive to Banner Life Insurance.
And what was the cause of his passing? Well, he was shot. Okay, so I don't know how I want to put that. Okay, all right. And I hate to ask, but is it? Yeah, you can just say yes or no. Was it a homicide? No, it was an accident. An accident.
So what we hear here is Lori Vallow being untruthful to Banner Life Insurance. We'll talk about credibility later, but it becomes very relevant that even in the smallest of things, this defendant exaggerates, minimizes, and is completely untruthful to various people. We all know that she was not the beneficiary. She didn't. But we also know that Charles Vallow was not accidentally shot. She told the police she was there. She knows that her brother intentionally shot him. Of course, they want to claim it's self-defense. There's no accident about that when you shoot someone twice. Motives for money. What we see again here is Lori Vallow talking to Chad about the motive. Telling Chad about the fact that it was changed. I just got the letter from that insurance company saying I am not the beneficiary. It is a spear through my heart. Who do you think he changed it to? Brandon? Or probably Kay? He left nothing for JJ. What do we know? Again, we see that Chad knows about all of these things. And what does he talk about in that morning as you have those entire messages? And exhibit 230. It will be interesting if he got changed after he had 2 bullets to the chest. Again, as we talk about the murder, we have later in that day the message that I talked to you about. So it was probably Ned before we got rid of him. We, not I, not my brother Alex, but we did. And then the other thing in this text message that is of importance is the fact that Lori Vallow knew a month before she went to Social Security how much money she was already going to get for the death of Charles. Here she says, I will still get the $4,000 a month from Social Security. When we talk about that motive and the anger by this defendant over not being the beneficiary, we know that even on July 28th, so 10 days later, she goes into Charles's computer to find the change of beneficiary form. She texts that to Chad to show him, and she sends it to Kay and confronts her about it. Money. That's what she wanted. And Chad. So let's talk about Chad. The affair with Chad Daybell. We know that she knew him as far back as November of 2018 when he came to Arizona and stayed at Lori's house. You were told by Detective Duncan that there were recordings on her Lori for Style iCloud account of Chad Daybell here in Arizona for that Preparing the People conference. You also heard that in the Lolly time, the later account that was created later, that in March of 2019, there were screenshots of flights to Idaho and back to Arizona with both Lori Vallow and Chad Daybell. This is during that time when she disappeared and Charles was taking care of JJ, and she's off flying to Hawaii and Idaho, living the good life with her soon-to-be husband. And then, of course, we know that come November 5th, she actually marries Chad Daybell. That KK Walker email address, this was that June 29th, big change. What do we know? That on April 21st, she created that account. She used her own phone number in creating it. And then she sent messages to Chad Daybell, Brother Daybell. You have that exhibit. She pretends to be Karen Walker and invites him to Houston, because that's where she is at that time. She offers to use Charles's money to fly him out there, and that he can stay at the house with her and her husband. In June of 2019, we see that Lori again uses that same account, but this time she pretends to be Charles and invites Chad out to Arizona to help him with a book. And again, in Exhibit 289, you have those letters. Charles finds those. And he lets everyone know he did. And he confronts Tammy, lets her know. Confronts Chad, lets him know. And he certainly lets the defendant know that he knows. And now the jig is up. We see in these text messages that were recovered from the iCloud accounts, whether they're under the Bubby context or under the Melanie 2 contact, this relationship between Lori and Chad.
There's no way we could read that.
Want to read the story, it kind of mimics them meeting in November, hooking up in hotels, and discussing their love for each other. When we are talking about a motive and a person who wants money and who has not worked for 13 years, who has had her husband pay for her homes, her phones, her cars, allowing her to go to the temple and work out and go to lunch and restaurants. This is a big change in life if she loses all of this. But if she gets $1 million, it's not so big of a difference, along with that Social Security she'll be getting. And then obviously we know that once Charles was out of the way, Lori and Chad were able to get married. So what about those religious beliefs? Everyone that Lori knew, who she expressed them to, told you that they were not in line with the Church of Latter-day Saints. Everyone told you that she said things like she didn't need to repent, she didn't need forgiveness, she could do whatever she wanted now, that she was in a celestial state, translated, that she is spiritually and physically changing, that she's above the priesthood, that she knew who was dark and evil. You saw those text messages, both about Charles and heard from people, as well as about Brandon and Zach and Adam. People who were helping Charles were also dark or Z's. And ultimately, what did we learn? That she associated herself with Nephi, a prophet, a holy man, who was justified and asked by God to kill Laban because he was an evil, wicked king who had the tablets that God wanted him to go get. Lori was just like that. She was justified in her killing. We heard from her brother, Adam, that their relationship had ended when she told him some things about her beliefs that he disagreed with. That she was turning into that celestial state, that she didn't need to eat, that she had more authority than the priesthood.
Yes. You yourself personally, were you aware of Lori having outside? Lori having any beliefs that were outside of what is accepted by the LDS religion?
Yes.
Can you tell us what you were aware of that you knew to be outside the LDS religion?
Lori told me that she was in the process of translating from a mortal human being to an immortal human being, a celestial state.
That's something that the LDS religion supports?
I haven't heard of it that it's happened here on Earth yet.
Serena Sharp told us about, again, the not repenting and Lori changing physically and spiritually.
Members of the LDS Church?
Yes.
During this time, did Lori ever tell you things about her beliefs that seemed to go against what you understood or what you were taught through the LDS Church?
Yes.
Did Lori ever tell you that she did not need to repent?
Yes, she did.
During this weekend, did Lori talk to you about her husband, Charles Vallow, being possessed?
Yes, she did.
What do you recall about her talking about her husband being possessed?
Nurse for God, thank you so much.
I recall that she spoke about her husband being possessed by an evil spirit, and she named the evil spirit.
Do you recall what the name was?
Yes.
What was it?
It was Ned.
N-E-D? Ned?
N-E-D.
Now, Serena Sharp was someone who met Lori in November, texted or talked with her for a while, and then was invited to that girls' weekend. One of the jury instructions you're looking at, and we'll talk about more, though, is the credibility of a witness. Serena Sharp has no dog in this fight. She knew Lori for a little while. She was invited to, I'll call it the inner circle. The defendant told her some things that went against her religious beliefs, and she said pretty much after that the defendant stopped talking to her. Now, how do we know she's being truthful? Well, we see Ned in lots of text messages. This just helps tell us that this is something Lori was telling lots of people, that her husband is possessed by this evil spirit, Ned. And we learn later that, like Nephi, she can get rid of him.
Do you recall Lori Vallow telling you that her husband Charles was no longer Charles, that he was now this possessed person?
Yes.
When Lori was talking to you about Ned, was she explaining that this evil spirit was now in the body of her husband?
I don't know if she used those exact terms, but that was the impression I got, yes.
So the word she used expressed to you that idea that this evil spirit Ned was now in her husband's body.
Yes.
The other thing that Serena Sharp told us was Lori using that term zombie. You remember how upset the defendant got by her saying that. But again, why would Serena make up any of this? She has no reason to.
What she recalls is that that is a term that this defendant used when speaking of people like her husband who were possessed by these evil spirits. We heard from Christina Atwood as well, the same concept that Lori Vallow repeatedly would say.
Did she tell you, as well as the other women who were at this meeting in February, that her husband was possessed?
Yes.
Okay. So it wasn't just you in a private conversation?
Correct.
She was open about it?
Yes.
So again, we see this ongoing timing of Lori Vallow talking of her evil, dark husband, who she later is authorized under her religion to get rid of. We know as well from Christina Atwood that there is a progression of these beliefs becoming more deviated from the LDS religion as she is meeting with her between February and June when she finally hears those words.
From the time you started meeting with these gatherings in February through to June, did you start to see sort of a progression of things that Lori was telling you that seemed outside of your faith?
Yes.
Did she make statements to you that you believed went against your religion?
Yes.
Did she at any point tell you that she did not need to repent anymore?
Yes.
What is that? What is that meaningful to you in your religion?
We believe that every single person outside of Jesus Christ has reason to repent.
Other than Lori Vallow, according to her words to multiple people. So let's take all of this, the motives and this timeline now, and talk about some of the jury instructions and all the evidence that supports proof beyond a reasonable doubt that this defendant is guilty. I want to start with talking to you about direct and circumstantial evidence. You have a jury instruction that tells you that evidence may be direct or circumstantial, that direct evidence is the testimony of what a witness saw, heard, or otherwise sensed, and circumstantial evidence is proof of a fact or facts from which you may find another fact. You're told the law makes no distinction between direct and circumstantial evidence. And this is relevant. The witnesses have often been questioned. Did you see, hear, or do that? What you are told is you can actually use circumstantial evidence to convict anyone. But let me give you an example of this. Imagine you are sitting on a beach. Just you, it's quiet. Off to your right, there's some rocks and you can't see around that. While you're sitting there, a person walks by, you watch them walk by and they go around the rocks and you can't see them anymore. And then someone runs up 5 minutes later and they say, hey, did you see someone come by here? You say, well, yeah, I saw them walk that way. That is direct evidence. You saw it. Now imagine you're on that same beach and it's completely empty. You close your eyes for 5 minutes. Just relax. Before you closed your eyes, the beach was completely pristine. And when you open them up, now you see footprints. You can see the toes facing off to your right, the heels, and you see them go all the way around the rocks there. Somebody, again, runs up 5 minutes later and they say, hey, did someone come by here? And you go, well, I didn't see them, but they must have gone by in the last 5 minutes because you can see their footprints. They went that way. That is circumstantial evidence. You can infer from that that someone went by and where they went. The burden of proof. The state has the burden of proof, as we absolutely should. So let's talk a little bit about what it is and what it is not. You're told that the burden of proof is proof beyond a reasonable doubt. And the instruction tells you that that leaves you firmly convinced in the defendant's guilt. You're told there are very few things in this world that we know with absolute certainty, And in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him or her guilty. So I want to start by saying what proof beyond a reasonable doubt is not. It is not proof beyond all doubt. It is not proof beyond all conceivable doubt. It's not proof beyond all possible doubt, and it's not no doubt. You're told that there are very few things in life we know with absolute certainty. So just because someone says, what if? That is not a reasonable doubt. What you're told is it's proof beyond a reasonable doubt. As we go through the evidence and apply it to the crimes, we will show you that there is no reasonable doubt as to this defendant's guilt. So let's start with the crime itself, conspiracy to commit first-degree murder. There are 3 stages in this, or 3 things the state must prove. 1, that the defendant or her co-conspirator caused the death of another person. Well, we know that Alex Cox shot and killed Charles on July 11th of 2019. Alex called 911. Alex indicated he was the shooter. He was the only one home. It was his gun. His credit card or debit card was in there with the gun. And we know that Lori told the police that her brother killed Charles. So we know that he caused the death of, so that. 2, that they intended or knew that she or a co-conspirator would cause the death of another person. When we are looking at this case, we are looking at the defendant's words, actions, and motive. The words and actions of having her brother Alex come over on the 10th with a gun so that he would be there when Charles came over to pick up JJ. The actions that day of taking Charles's phone, ensuring that he could not leave, that he could not take his son to school. The defendant told the detectives how angry and screaming Charles was about the phone, but she didn't just give it to him, throw it at him, tell him to get out, whatever you might do. She held onto it and told the police that she walked away with it as he's trying to grab it. The defendant's actions and words show us that she is the only reason why Charles stayed in there and the only reason why Charles was shot. Then there's those 12 minutes. The defendant tried to pretend that this was a quick, angry scuffle. But Charles is there for 12 minutes. The defendant is there for 12 minutes. Alex is there for 12 minutes before she leaves. We look at her actions when she came back. She told the police her brother was hit in the head with a bat. She never asks how he is. She's not concerned about his injury. She's not concerned about her husband being dead on the floor of her house, her child now without a father. The lack of words that she said there and her demeanor show again that she was well aware of what was going on and part of this incident. We look at her words to Chad, that Charles changed his life insurance policy before we got rid of him. They show her intent to kill Charles. And again, we look at the motive, money and Chad. When did this happen? The first time Charles came back into town after he found out about the affair. Finally, the state has to prove that the defendant or the co-conspirator acted with premeditation. So I'm going to talk to you about premeditation. You have a jury instruction for it, and it tells you that the defendant or the co-conspirator intended to kill another human being or knew she or the co-conspirator would kill another human being, and that after forming that intent or knowledge reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. You're also told an act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. This is where you remember those 12 minutes and the calmness of her walking around with that phone and her demeanor. You're told the time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. So I'm going to give you an example. It's a lot of legalese, and then we'll talk about what we really have here. So imagine again, you are driving your car. You do every day, and you're coming up to an intersection and you see the light turn yellow. And in that second you think, do I want to run it? Or do I want to slam on my brakes and hit stop before I go into the intersection? You think about that, and then you decide, I'm going to slam on my brakes, and I'm going to stop. That is the time it takes to reflect. That is the time it takes for premeditation. But we have a lot more than this because we have planning, not just premeditation that morning. So when we talk about the premeditation that we see, it starts at least back in June, when we have Christina telling us about Alex Cox saying that he wanted to kill Charles, Lori having no reaction to that, and instead talking about drugging Charles.
Did you hear Alex making some comments?
Yes.
And you told us that they made you uncomfortable. What were these comments?
He stated he wished that he could just kill Charles.
Okay. Was Lori around when he was saying this?
Yes, one of the times.
Okay. So he said it more than once?
Yes.
Can you describe first part of his demeanor when he's saying this about wanting to just kill Charles?
It was jocular, just...
Jocular? As in joking?
As I recall, he was standing up and just talking about it pretty loudly.
And you said one of the times that he said this, it was around Lori.
Yes.
Did she react in any way to hearing her brother say that he wished she could just kill her husband?
Not that I recall.
By July 9th, or when we start having this planning that we're talking about, we know that Lori Vallow is living in a house paid for by Charles Vallow. We know from even her statements to Detective Enclan that she doesn't like Charles, is what she says, but Charles won't file for a divorce. We know from her words and text messages that she wants to be with Chad Daybell, but Charles is her cash cow. She hasn't worked. He pays rent, car, cell phones, her travel. And so, as far back as June 9th, we're already hearing that Alex and Lori would like to not just get rid of Charles, but kill him. But if you think that June 9th wasn't the beginning of this planning, this idea, this concept that Lori and her brother have of getting rid of Charles, this evil, dark, possessed person, that we know on the 9th that there is definitely a plan by this defendant. And we see that through those text messages with Melanie, with Summer, with Alex, where she speaks of the mission, where she talks about telling Melanie, you can't leave. You got to pretend to be sick and stay here and keep track of Brandon so he doesn't come help Charles. He can't be in the picture. We need to stay here to defend ourselves from an intervention. The 10th, Again, we have Melanie, who is talking to her and saying, that she wants to just go to this wedding. And what does Lori tell her? No, you have to stay here for the mission. The mission of stopping an intervention? No. As we continue through the 9th, we see Lori getting everyone lined up to help her. Alex, where he again is told that he will be like Nephi, just like her. Now Lori tells him it's an intervention. Everyone knows, Adam told you what's an intervention? It's talking to someone. It's common language. But that's not what the defendant wants to happen. She doesn't want Charles to divorce her and lose his money. She doesn't want this intervention to happen where she loses her temple recommend. What she wants is to be like Nephi and get rid of her husband.
Well, Nephi was a prophet in the Book of Mormon. It's the first chapter. He was a prophet, very humble and faithful servant of the Lord. Ironically enough, his brothers tried to kill him at one point. But he actually ended up going to Jerusalem to get these plates back, and he was run off, came back, and then went back again because the Lord asked him to. And when he did, the King Laban, who was actually a wicked king, was laying on the ground drunk in front of him, and Nephi was told to kill Laban.
Who was he told by?
The spirit, or God.
So God was using a Holy Spirit to tell him to kill Laban, and
Yes.
did he?
Yes, he did.
Was that something he anguished over?
Yes.
But ultimately, it was a justified killing.
Yes.
You heard from Detective Duncan that everyone he spoke with gave this same story. And again, the defendant questioned others about this story. But what we've heard is, from Detective Duncan and from Adam, that Nephi is this justified killing. When we think about her religious beliefs and what she's been telling people about not needing to repent, about telling people who is dark and evil, a zombie or a Z, that she is above the priesthood, it makes sense that she feels justified in determining who should live or die, just as she told her brother on the 9th. And we know that in fact we're talking about a justified killing because Alex brought a gun over. He didn't bring the Book of Mormon to talk to Charles about something. He didn't bring a friend to try to record Charles saying something. He brought a gun with him. And then he waited there for his sister's husband to come into the house so he could kill him. What we see is a very planned out, premeditated murder. But let's talk about some additional premeditation. Again, as we're looking at Summer, we see on the 10th that Lori is having her sister update her on where Adam and Zach are staying, so she knows they're not with Charles. They're not coming over. They're not going to be interfering with their justified killing. And there's that 12-minute time where the defendant desperately wanted to rewrite the timeline as they told the police that day. This just happened. It was very quick, but it wasn't. It was 12 minutes. Charles arrives at 7:37 and Lori leaves at 7:49. During this time is when that plan, that premeditated murder occurred. So let's talk about that as well. The evidence at the scene, the physical evidence, supports this premeditated murder. Alex fired 2 shots. One of them went through Charles' center mast, exited out his back, and went into the floorboard. The second one, Charles was on the floor, on his back, bleeding out, still able to move, and we know that because he had blood on his left hand, and he was executed as he lay there on the ground. In that time, when we talk about premeditation and reflection, as Adam had to move his hand down, reposition the gun, and discharge and pull the trigger one more time, that is premeditated first-degree murder, no matter what you believe before that. Again, when we talk about that physical evidence, we saw the fact that the location of that bullet defect in the ground matched right under Charles's left shoulder. And we heard from Dr. Baumgartner. Dr. Baumgartner told you that this was a classic shored wound. And no matter how many questions could be asked about him of maybe a bamboo shirt might stop a bullet in one location but not in another, or how many matrix-like hypotheticals where maybe Charles bounced back up and then on his way down, the bullet slowed down through him and waited till he hit the ground again before it exited. Dr. Baumgartner told you, no, those hypotheticals, those issues did not make sense. He's never seen a t-shirt stop a bullet in one location or at all.
Bingo on the Matrix.
And we know Charles didn't bounce because we know he had no injuries to the back of his head. This also tells us a little bit about the shooting itself. When Charles was shot that first time through center mast, he did not fall straight back and land onto the ground, laying there on his back.
It's not center mast. He's not a ship.
If he had, he would have had bruising, abrasions on the back of his head when he hit the ground. He didn't have anything on the back of his head. Where did he have abrasions? On his knees. When he fell to the ground after being shot, do we know how long it took him to roll over, to fall onto his back, before he was then shot a second time because he's still alive? You heard it could take up to 2 minutes for Charles to have died, and that he could have spoke and moved during that time period. What we do know is that he eventually ended up on his back. And while he was on his back is when he was shot the second time by Alex.
She said it
This
twice.
defendant and her brother in that house waiting and making sure that Charles was dead, murdered, executed. Words, actions, motive, and physical evidence all tell you what happened that morning. So let's talk about conspiracy. And I know there are a lot of layers here, and I'm just building them up for you.
Building an onion.
You're told in your jury instructions that conspiracy requires proof. 1, the defendant agreed with one or more persons that one of them or another would engage in certain conduct. So again, we look to Lori Vallow's words. What she had been talking about for months, Charles being possessed, being dark, wanting to kill him, the discussion on June 9th, poisoning him or drugging him previously. And then when we got to July 9th, it is all coming to a head. We will be like Nephi. Her actions, having Charles come to the house, instead of him staying there, she had him stay away. Why? Because if Charles stayed at the house, couldn't have Alex come over with a gun and be ready to shoot him, right? You got to have him come in. Her actions of inviting her brother over with a gun the night before so he would be there. She knew when he would show up. He texted her, "I'll be there at 7:30. Pick up JJ." But most importantly, why did Charles stay in the house? Lori told the detective that Charles initially was like, "Oh, I'll just stay here for 20 minutes and then I'll take JJ to school." Well, she wasn't going to kill him in front of JJ. No, take JJ to Burger King. Get him out of the house. Go put him in the car. And he does that. But then she takes his phone. And she won't give it back. What she told the detective was, before this alleged Tylee bat, whatever thing you want to talk about there, that she had Charles's phone and was asking him about texting Adam. Of course, that's interesting because how would she have known that? But we know she had the phone actually for a while before she did that interview. She tells the detective numerous times that Charles is telling her to give him back his phone, and she will not. That she's walking around as he's trying to get the phone. She won't give it to him. Why? Because she needs Alex to come out. He brought that gun over for a reason. So she agreed with one or more persons, her brother, Alex, that she intended to promote or assist the commission of such conduct. Well, of course, we know both the promote. She is the one who on the 9th said, "We will be like Nephi. It's time to stop this whole thing. Charles trying to take my temple recommend, all this stuff that's going on. Time to kill him." And of course, she assists by ensuring that Charles stays in the house when she takes that phone. And of course, they knew that it would constitute first-degree murder. That's what Nephi did. Only unlike Nephi, where it was justified, here, ladies and gentlemen, this murder was not justified. Finally, think about the demeanor when you're thinking about, again, words, actions, motive, and demeanor. When Lori comes back to the house, she is very, what did we hear that word many times? Nonchalant, calm. No questions about her brother, no questions about her husband, no questions about the house, just laughing about her neighbors. She is in absolute agreement with what has happened. She knows what's happened and she's calm and good with it because she doesn't need to repent. She is able to determine who should live and die, and she has done that. So when we talk of the scope of conspiracy, you're told that to prove a conspiracy, it is not necessary to show a formal meeting or express agreement. But we see that from the 9th, in that conversation that she and Alex had, where she tells him, "You are going to have to stay near me for the next couple days, and we will be like Nephi." You're also told that a conspiracy may be inferred from circumstances showing a common criminal objective. So, because you don't have someone who says, "I heard them say, we shall conspire," you can infer that from the conduct. The conduct of what happened on the 9th, the conduct of what happened on the 10th,
Is the
and the
important
conduct of what happened on the 11th. All infer to you a conspiracy of Alex coming over with his gun to shoot and kill Charles.
The conspiracy is definitely inferred. The jury needs to reach that conclusion to find guilty.
As we again look at this and this conspiracy, again, we're looking at the same words and actions. March, Charles is no longer there. There's just an evil spirit in his body. June, Charles is still possessed, and now Alex is saying he wants to kill him. Lori is fine with this, and she says she's drugging him, or had been drugging him. And then 2 weeks before, all of a sudden, Charles knows Lori's been having this affair. Lori's words, actions, motive, and the physical evidence.
Read fast. Cameraman doesn't like PowerPoints either.
Conspiracy again, we see that Lori and Alex know exactly when Charles is showing up. Alex doesn't go to the door according to Lori and confront Charles or tell him we'll send JJ out and you can leave with him. The world is so difficult. How hard would that be? Bring JJ right to the door and let him leave with his dad. No, you aren't going to shoot him outside. You want to make it look like self-defense inside. As you go through this and we think about what's going on, the defendant doesn't even care. She wants her husband killed so bad that she's willing to let her brother bring over a loaded gun in an unlocked gun case in a house with a 7-year-old autistic child. That's fine. When the defendant was questioning Detective Enclan, she was talking about how hot it was outside. JJ's out in the car. But she has no problem with an unlocked gun in the house with the kid, and she's worried about her child out in the car? She's not. We know that because she's the reason Charles doesn't go back out into the car and leave. She keeps him there in the house. She is why JJ's out in the car alone. She has to keep him there until Alex comes out and can shoot and kill him. When we talk about that premeditation, obviously we're talking about that message. We know from the 9th on, they are premeditated, they are conspiring, and it's all heading to July 11th. We look at the timing of this, and this is actions and non-actions. Charles is in the house for 12 minutes. After those 12 minutes, they wait 47 more minutes before they call 911. Why? To stage the scene. No CPR is performed. They wait for Charles to be dead, and then they talk during this time period. They talk. They could call 911, but nope, they're going to just talk. So again, you're looking at their actions, what happened and didn't happen, and the motives. There's the gun that was used to kill Charles. We're going to go through a couple of these exhibits, some of what Lori said, and it's exhibits 192 and 197, where she again says that Charles came over and said he was just going to hang out at the house for like 20 minutes, take JJ to school. She, of course, tells him to go. And when JJ is out in the car, she has Charles's phone, and she won't give it back. And no matter how much she says that Charles is screaming at her to give the phone back, she won't. And all of this conversation about Charles demanding the phone back is prior to her statement to Detective Enclan that Tylee comes out with this bat. This is all her doing. This is her as an accomplice assisting and promoting this murder. Lori is setting up Charles so Alex can shoot him.
And with JJ?
And so he put them in the car,
Okay.
in the driveway, and then he came back in, right? So I kissed JJ goodbye. He came back in, and his phone was on the counter, and I had his phone. And he was like, giving me my phone, and I was like, why don't you show me your text that you've been texting, blah, 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 you know, whatever. Because he's like acting really weird, like he's plotting something against me. Like, I'm like, why are you even here? Like, what did you come here for, you know? He's been talking to my other brother, and my brother came into town at the same time last night. And I haven't talked to my brother in a while, my other brother, and I was like, and so he was texting him on the phone when he first got to my house, and I'm like, why are you texting Adam? Like, do you even talk to him? Like, my other brother.
So when you listen to these clips and the interview of Lori Vallow, you have to put into context. This is 9:52 in the morning
Tammy,
when
thank you
this
so much.
part of this interview is occurring. And she's telling the detective that she confronts Charles about texting her brother Adam. Now, she's had the 47 minutes she's been driving around, and then that time at the house when she's waiting outside to learn all of those texts and what's been going on between her brother and Adam and Charles. And so she is now mixing this in to her interview. And so when you're listening to her interview, we know she's trying to work out this, what happened, how did this go? You can watch her demeanor as well. And as you're going through this, see how she's just telling a story here, like what happened, almost chuckling about it.
Okay. So this morning he comes back in and...
He comes back in, I wouldn't give him his phone. He was screaming at me to give him his phone. He was very worried about whatever was on his text that he did not want me to see. And so I was just holding it there, and he was screaming at me. And I was kind of walking towards around the house with it, so he couldn't get it. He's like reaching for it and stuff like that.
So again, JJ's in the car, Tylee's not out, Alex isn't out, and she is making sure that he doesn't leave. She's walking around the house, holding his phone, refusing to give it to him, making sure her autistic child is sitting out in the car even longer so that she can ensure that exactly what they've been planning happens, that Alex has time to come out with the gun that he brought over and shoot and kill Charles. This defendant is the only reason why Charles didn't leave with JJ. This defendant is the one who provoked Charles by taking his phone and refusing to get it back. This defendant is the one who ensured that Charles was inside without JJ so Alex could shoot him. And this defendant is the person who set up Charles so that her brother Alex could shoot him. So let's talk about staging the scene. We know obviously from the first responders that when they arrived, no CPR was given. You heard from Officer Wierzbecki that when he felt Charles's neck, he thought he was dead already, but they still let the first responders in because they've been told CPR had been given. And what do we know? That they arrived within a few minutes. No one had ever tried to save Charles. No blood had been pushed out of him from CPR, whether strong or light. He had been dead for quite a while. His skin was mottled when they started cutting open his shirt and looking to the back, and lividity, the blood pooling, was occurring already. So they kind of knew something was off with that timeline. So what about the scene itself? The bat. It is placed to the right of Charles to look like he was using it. He got shot and it went flying behind him. Well, obviously we've heard from Kay, Charles's sister, that he was left-handed. We know from the blood evidence on his hand he was left-handed. There's no damage to that mirror. There's no damage to the drywall. There's no damage anywhere, like this bat is being swung around in this horrific fight that's going on of grappling. The injury to Alex Cox's head. You heard it was a small 1-inch cut that he was using a paper towel to pat, and at times, as you watch that Exhibit 1, rubbing it. making sure it stays bleeding. There is no blood at the scene from this giant grappling thing going on that Lori Vallow wanted them to believe. His head is bleeding and they're grappling around and he's being beat with this bat, and yet not one drop of blood on the floor. Not one drop of blood going down the hallway when he put that gun away. Not one drop of blood on the gun itself. And then the shoes, left by the door to look like Lori Vallow had run out in fear after this horrific incident that they planned. But we know from the Walgreens video is that she did enter the store with shoes. Something on her feet.
She was wearing
So
shoes
we're
when
gonna
she
go
went to
through.
go
You know,
buy shoes
Charles
because she
Gann,
didn't have any shoes.
Left-handed?
Field with your brother.
Yeah.
What position did your brother play?
He was a pitcher. He was very, very good. He was a left-handed pitcher, and they're very hard to hit against.
Okay. Did he bat right or left-handed?
He was left-handed.
Do you do everything left-handed?
Yes.
Left-handed? So we know that Charles batted left-handed, not right-handed. And what we know is Lori Vallow had a story about how Charles was using that bat. And it becomes very important as well when we're talking about the staging of the scene. This is Exhibit 193.
Yeah, she was outside, and
then what happened?
Then they got up from that, and my brother had like stepped back, I guess, and then Charles was coming with me at the back, yelling at me to give him his phone still, because I had it in my hand. It was all really quickly, and then when I went around kind of in the circle, then my brother was there.
When you said when you were going around and he was coming at you with the bat, how was he holding the bat?
Just like that, like backwards, almost in one arm.
Like he was swinging it backwards? He would have done like
he would have swung it backwards at me, not frontwards.
Okay.
So Lori Vallow, detective, and planned that Charles is swinging the bat backwards. Now, if the bat was like this when he was shot, the arm would have been shot. Covers his center mass. So we know he wasn't here. So if he's out here, where would the bat go? Down, out, somewhere that way to his left. It would not end up thrown up above him. And if it wasn't there again, Charles would have been shot through the arm. Obviously, Alex forgot that Charles was left-handed. So when he placed that, like he was coming at him with a bat, their stories didn't quite match up with the evidence. So if we rely on Lori's story of how Charles was holding the bat, then there's zero way that that bat would end up where it ended up. And again, we know he's left-handed from not only Kay, but his own admissions of that blood on his hand. So we see the scene is staged, this bat that is so necessary to try to ensure this justified killing is legally justified and not just spiritually justified. When we talk about the scene as well, and you're looking at where Charles was, at least when that second shot went through him, you can see in the photograph to the right, the shot to Charles's chest, right between his nipples, and the shot to Charles's abdomen, down lower. We know that that first shot through his chest, that Charles would have been facing a little more towards the open area there where we see the hallway and the kitchen. We know that because there was the bullet trajectory Detective Pickles told you about that entered that far east wall. We know there was stippling, and so the defendant would have been, well, her brother would have been within 2 to 4 feet of the muzzle of that gun, within Charles 2 to 4 feet. We know from the lack of that injury to the back of his head that he didn't fall straight back. We know from the blood on his hand that he was still alive after he was shot. And we know the lack of stippling for that shot to his abdomen and that trajectory, and even the defendant's own statements that she saw her brother at Charles's feet, that he would have stood there at Charles's feet when he fired that second shot as he was laying on the floor.
We might not get to deliberations.
You
tonight.
have the bat, Exhibit 249. You can look at the edge of it. You see the photograph of the edge of it. There is no blood and no damage to this bat. Regardless of how many times the defendant was hoping that blood was invisible, we have all cut ourselves and seen that blood is red. And there was no blood on this bat. There is no blood on this bat. There is no damage to this bat. So you have a semi-professional baseball player who has a bat in his hand and he sees someone with a gun and he doesn't beat him with it, take his head off with it, knock him unconscious with it. Instead, all we see on this bat is 0 damage and 2 partial prints. No prints of a body or smushed skin on it. Someone that's sweating from a fight that's left a large arm print on it or anything else. Nope, just 2 partial little prints on it. When you think about what is there and what isn't there, does the evidence of this bat fit in at all? It doesn't.
Who said no? Somebody said no in the courtroom.
We look at Charles's watch.
You
No
guys hear
damage
that?
to it. No scratches to it. No dings to it as he's grappling on the floor like Lori wants you to believe. We know that at some point Charles is standing and shot, and we know that final shot he's on the ground. We know he fell to his knees at some point.
We are at 1 hour, 30 minutes.
And when you look at that physical evidence and the lack of damage or anything on that bat, again, what makes sense is that Charles fell to his knees after that first shot. We know that there is 12 minutes where the defendant and her brother are still together there, so that Alex can get this 1-inch cut to the back of his head that's barely bleeding, that he uses a paper towel to dab at and rub. The shoes that the defendant ran out of on her way out. You have the exhibit. You can see black straps across her toes as she enters and exits the Walgreens. And then you see that she's wearing the flip-flops when she comes back to the scene. What do we know? That the police did not search Charles's rental car. Credibility. You are given a credibility instruction and you use it for everyone, including the defendant. You're told that you really evaluate people the same way. You're looking for any inconsistencies in their stories, any reasons why they may have a motive or bias to lie, any prejudice they may have, and then you look at everything in light of reason, common sense, and experience. When you think of the testimony of the people who've come here and talked to you, Christina Atwood, Serena Sharp, Nancy Jo Hancock, Adam Cox, Dr. Bumgardner, the detectives, Robin Smith Scott, Mark Zari, what benefit do these people have in being untruthful to you? They have body cameras, they have prior documents, and they have memories of what this defendant said. But the credibility of Lori Vallow is something you do need to consider. And you start with her demeanor that day, where she wasn't worried about anything when she arrived. Her brother has allegedly been hit in the head with a bat by her husband who plays semi-pro ball. She doesn't even worry about him. She knows he's not hurt. He's fine. And why does she know that? Because that was staged.
She was
When she's there and we see her on body cam arriving, just nonchalant and calm. And I know the defendant wanted to make sure that it was clear that everyone else was calm, but no one else had just allegedly seen their husband get shot and killed by their brother. When you were looking at the reasonableness of her testimony, you have to consider it in the light of reason, common sense, and experience. And the way that she was acting and reacting that day, as well as her own statements, do not fit the evidence, do not fit the physical evidence, and you will see her credibility throughout this whole case has been questionable. Her credibility with Social Security. What did
Who does
we
she
learn?
keep looking over at?
That on July 11th, she tells Detective Enclan that she and Charles are separated. It's Exhibit 187. We are not living together. Charles rented her house. We're separated. But on August 12th, when she needs to make sure she gets some money, she tells Social Security, when they ask, are you living together at the time of death? Yes. You also learned that she was not truthful with Social Security when she got remarried. She did not tell them about that either. So we know she's been untruthful to Social Security twice. Why is that relevant? Because you're judging the credibility of Lori Vallow throughout all of this. Life insurance. We know that she said Charles was accidentally shot. We know that was not true. She wanted to make things seem like she had nothing to do with the murder. But we know that Alex Cox intentionally shot Charles. Whether or not she wants to claim it's self-defense or not, there was nothing accidental about shooting him twice. Then that second call to Banner Life Insurance, where she tells Robin Smith Scott a few different things to garner sympathy, and she asked her if she could do anything about the change in beneficiary.
I really can't give too much information, but I can tell you that the beneficiary was changed in March of this year. Okay. Okay, I'm trying to figure out what he was doing since we have 5 kids and we've been married for 15 years. Oh, I'm sorry.
So Lori tells this woman, we have 5 kids, which if you want to count them all and admit that 3 of them are adults, then okay. Really, they have 1 kid in common. Tylee, you learned, was actually getting Social Security survivor benefits from her dad's death starting in 2018. Lori's son, Colby, isn't living with them. Charles' son's never lived with them. Why does she say these things? She can't help it. She just wants to just make herself seem better than she is.
Or she might be a lying liar who lies.
What about the credibility of her interview, even during the police interview? We've talked about a few things, but one of the things she told the detective.
And I didn't file anything or whatever. And then he filed something against me and said, I'm only going to get supervised visits because I'm crazy and blah, 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 you know, the story. And so I just didn't talk to him for like 30 days and let him take care of him and let him see what I've been doing.
So again, she can't even be honest and say 2 months. She's got to be like 30 days. I was kind enough to just leave my husband with my son for 30 days. What we know is that Lori Vallow was gone a total of 78 days, 58 while she's flying to Hawaii, going to Idaho and back with Chad. And who's taking care of JJ? Charles. And Kay is coming here regularly to help take care of JJ, to help run the business. And then eventually on March 28th, that's when Charles finally decides he hasn't been able to find Lori. He doesn't know where she is. He's going to move to Houston to be closer so his sister can help him more easily. And this is when Lori finally shows back up. So again, even the simplest thing of just trying to be honest about how long she's been gone, she has to minimize it and make herself seem better.
With your cross.
The shoes. If this will play. When she was questioning Detective Enclan, She was asking her if it was hot in July and if she would need shoes to go take her son to school. But of course, what we know is that we saw her with those shoes on as she went into Walgreens. So again, it's continued trying to garner sympathy and just being untruthful about whatever she feels like being untruthful about. And then we look at the credibility in that timeline, that body cam.
You know, now that you're not in Santan, this is your home?
Right,
Gotcha.
right.
Okay.
We just moved in here.
Gotcha. How long have you guys lived here?
Sorry?
How long have you lived here?
Like 3 weeks.
Oh, geez. Yeah, okay.
That's why the neighbors don't know us.
Gotcha.
Like, hi neighbor, sorry.
Are you working?
So here she is, 47 minutes after leaving the house, laughing and smiling with the detective about the fact that her husband is dead inside the house. Her brother is sitting on the curb, allegedly with this very serious injury from a baseball bat.
Skull bashed in.
When you look at that credibility of the defendant, you have to look at everything together and what fits, again, with the physical evidence and what doesn't. Finally, let's talk about the justification
Finally,
defenses.
this is the second finally.
What we know is that Lori Vallow thought she was like Nephi, that she was justified in killing Charles. That her brother, who was supposed to be like her, was also justified in killing Charles. But Lori Vallow is not justified under Arizona law, nor is Alex. So let's go through the different justification defenses. First thing that you have to consider for every one of these, self-defense, defense of a third person, or crime prevention, is the non-justification for use of deadly physical force. You are told if a person is not justified in using or threatening physical force or deadly physical force against another in response to verbal provocation alone. So Charles yelling and screaming at her to give his phone back does not justify you shooting him. Or a person is not justified in using or threatening deadly physical force if the defendant or co-conspirator provoked the other's use or attempted use of unlawful physical force. So we know here Lori provoked Charles by taking his phone and refusing to give it back.
Gesundheit.
So again, when we look at every one of these defenses, you'll see not only do they not apply, but none of them is the defendant entitled to. This is not self-defense. In self-defense, you're told that a person, a reasonable person, can use deadly physical force if they believed that deadly physical force was immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful deadly physical force, and the person used or threatened no more deadly physical force than would have appeared necessary to a reasonable person in this situation. We know that Lori Vallow used Charles's phone to get him to come back inside, and she used his phone to keep him inside and give her brother time to come out and shoot and kill Charles. We know from the physical scene itself that Charles did not use a bat. We know from the physical evidence of Alex's 1-inch cut to his head and the lack of blood or concussion, the lack of damage to the mirrors, the walls, the location of the bat in relation to Charles, they all tell us that Charles did not use a bat. We know that Charles was a semi-professional baseball player. This would not have ended that way if he had had a bat. But even if you somehow think that he did have a bat and he was swinging it at Alex, the defendant, whoever, he still was not justified in shooting him when he was on the ground. It has to be immediately necessary to protect against another's use. When Charles is on the ground and he is shot that second time, there is no threat to anyone. And so that is not self-defense.
Counsel, I need to give my court reporter a break unless you think you'll be done in the next 5 minutes. Okay, go ahead.
When we look at the physical evidence, again, we know that Charles was on the ground.
We're so grateful
shot,
for court reporters.
and so this is not self-defense. And we know from the physical evidence at the scene, the projectile into the floorboard, this is not self-defense. Third party. You're told that a person is justified in using or threatening deadly physical force in defense of a third person, I presume here Lori Vallow. If a reasonable person in this situation would have believed that deadly physical force was necessary to protect against another's use, again, of unlawful deadly physical force against a third person, and they used only what was necessary for a reasonable person under the situation. What do we know? Lori Vallow told Detective Enclan that she wasn't even in the room when she heard the shot, that she had gone around into the kitchen. Who's he protecting at that point? What third person that's no longer there is he protecting? You can't protect against a future, what might happen, or what already occurred. It has to be now. And Lori Vallow herself put herself outside the room when her brother shot Charles. So there is no third-party defense. But again, the same thing applies. Even if you thought so, that second shot removes any possibility of being justified. Crime prevention. This is the exact same thing, only in a slightly different stated way. But like self-defense, it allows a person to use deadly physical force against another to the extent a reasonable person would have believed that deadly physical force was immediately necessary to prevent Charles from committing aggravated assault against Lori Vallow. We know she's not in the room. Even if he had that bat and had been coming at her and then she left the room, that crime is over. And again, even if you believe he had the bat, you cannot shoot him while he's on the ground. That is not what crime prevention permits you to execute a person. Finally, there's mere presence.
It's a third, finally.
You're told that guilt cannot be established by a defendant's mere presence at the crime scene, mere association with another person at the crime scene, or mere knowledge that a crime is being committed. Lori Vallow wasn't just present at this crime scene. She brought her brother to the crime scene. She ensured that he brought a gun with him. She ensured that JJ was outside, and she ensured that Charles stayed inside. She was not merely present. She was a person who was actively participating in this crime. Ladies and gentlemen, we have talked about the evidence in this case. Evidence that was presented to you through witnesses who took the stand and exhibits that were admitted for you to review. Remember the evidence of Lori Vallow's motive. Charles's life insurance, Chad Daybell. Remember Lori Vallow's own words of wanting to get rid of Charles, of drugging him, her acceptance of her brother's statements that he wanted to kill Charles, how she used Melanie and Summer to plan her mission and ensure that Charles didn't have help from Brandon or Zach or Adam. Her words to Alex about it all coming to a head, that he had to stay near her and they would be like Nephi, justified in killing Charles. And finally, her words to Chad Daybell on July 18th, confessing to the killing when she said Charles had changed the life insurance before we got rid of him. Look at her actions and demeanor, having her brother come over on the 10th to her house with a loaded .45 caliber handgun, creating the one and only reason why Charles stayed inside the house, why he didn't just take JJ to school. The 12 minutes that Charles is at the house before Lori leaves in the car, the 47 minutes after that before they call 911, her demeanor when she comes back, not caring that anyone has been hurt, her demeanor on the body-worn camera, during her interview, what you heard about during the drive. Think about her credibility, how she cried for you in her opening statement. You certainly didn't see her cry on that body camera footage. You didn't hear about her crying as she was being driven to the Family Advocacy Center, and you did not see her cry in her interview. Finally, think about the physical evidence that proves that Lori and Alex staged this scene.
This is the
That
fourth
Charles
finally.
was never in possession of that bat when he was shot by Alex, or either of the shots. That instead he was executed that day for this defendant's benefit. The physical evidence disproves beyond a reasonable doubt that Lori Vallow and Alex Cox were justified under the law in killing Charles. The jury instructions tell you to use reason, common sense, and experience. Charles Vallow is dead today because this defendant and her brother Alex Cox conspired to kill him. They planned it out, and they had their weapons, and they orchestrated a way to ensure that Charles was back in the house where he was shot and killed for money and Chad Daybell. The evidence proves to you that Lori Vallow Daybell is guilty of conspiracy to commit first-degree murder, and the state asks you to hold her accountable and find her guilty. Thank you.
Everyone gets
All
a
right,
break.
we're going to take our 15-minute afternoon recess. I'll remind the jurors to remember the admonition. We'll resume in 15 minutes.
The judge is like, I'm out of here. I've got to pee. The court reporter has to pee. All the jurors have to pee. Okay, that was long. It was very long. And for our benefit, the only thing, I was checking this off, the only thing that she did not mention during the closing that was mentioned during trial was the green chili and chicken enchiladas. She pretty much covered everything else. So if you missed the trial, don't feel bad. You heard it all right there in the last 2 hours. Everything except for the green chili chicken enchiladas. So that's good. So we're all caught up now with trial. We've got a 15-minute break, and then Lori is going to take center stage, so to speak, and give her version of a closing, which should be exciting. And I'm here for it. I'm here. I can give Lori 1 hour of my time. That's what. If she takes longer than that, I'm sorry. It's Trina's fault. The state wore me out. But Lori, you've got 1 hour from start to finish. So try to hold me to that. Laurie Lee, Annie, Scott loved your live enchilada stream, so thank you. And Mrs. R.A. have to lurk a bit more often now, but I'm still here. Thank you for you. Laurie Lee, thank you. Also gifted 5 memberships. Thank you. That is super generous. That is awesome. Let's see. I heard center mass, though I played with Jets for 20 years, so hearing is not my strength. I heard center massed twice and center mass once in the 3 times she referenced it during the closing. But that's just me. I've got tinnitus as well, so I could be wrong. I also heard somebody say no when she asked a rhetorical question. So I don't know who that was. It was a guy's voice. Lori has prepared green chili chicken enchiladas for the jury to eat while they deliberate. Dinner provided by the defendant. That should become a thing. Only if you want more murder trials. Mackenzie gifted 5 memberships. Thank you very much. Jabali? Is it Mackenzie Jabali? Thank you. Thank you for your generosity. You guys are super kind. That's the green memberships are being flying out the door. Wow. Oh, hang on. I'm on top, chat. I'm missing all sorts of remarks here. Just 1 second. Let's go back. I missed a couple. Let's see. Lynn Britton says, 17 months, by the way. Late, had to be on a replay crew to catch up. Thank you, Ari. Always a fun time listening to cases with you. Thank you very much, Lynn. Selena K gifted a membership. Nikki Zeebs, member for 24 months. One of our OGs says, yeah, I'm finally pink. This has been the best 24 months, Ari. Thank you so much for everything that you do for us to make this community the best. Winnaboo, member for 14 months. R.A. loved the cooking show you and Miss R.A. did. Made a great team. I laughed so much. I needed that. Please, more cooking shows. We'll be trying It love hot food. Kelly H gifted a membership, kicking stuff off there as well. Andrew C, member for 24 months. Another Pink Courthouse OG. 24 months. Fun fact. I had a pink wheelchair when I was a child. I painted it after a few years. Glad to be here. Lynn Keeble. Welcome to the gallery. 4 months. There you've got that green courthouse. Looks great. It changes color again at 6. Courtney Arleo, member for 24. Lots of people hitting the 24 months. OG level. Special thanks go out to RA, Mrs. RA, the little RAs, mods, and chat for making this best internet community ever. It wouldn't be the same without you here, Courtney. Thank you very much for your support. Let's see. That was Courtney. Shy Gal 8, welcome to the jury. Brand new member. Welcome to the jury, Shy Gal. I'm sorry I missed that when that came in. Welcome. You're one of us now. You can never leave. Thank you. Nurse for God gifted 5 memberships. Tammy E gifted 5 memberships. Larly Annie, there's the comment we just posted up there as well. Amazing. Mackenzie Jabley gifted 5 memberships. Kimmy, member for 14 months, says, Ari, your green chicken chili enchiladas were probably better. Thank you, Kimmy. We ate all of them. I was going to give some away, but I ended up eating them. Mod's calling, guys. We have to stop for a minute. It means I did something wrong, probably. Hey, Amber, how are you doing?
I'm good. How are you?
Good.
Wonderful. I thought I'd take this second while we have a break in court to kind of update everybody for those that have been asking, since I haven't updated in forever.
Okay, can I
My
finish?
mom.
Oh, sorry, go ahead.
Yeah, go ahead. Yeah, you go. Go.
Okay, let me finish on the up news, because I know that this is some heavy news. Josh gifted 10 memberships, and it's amazing. Josh, thank you very much. Maggie Carr, member for 26 months, says thanks for RA for everything you do. And Katie Bug gifted 5 memberships, and Laura Leanna gifted 5 memberships. Whew, I caught up. Okay, now Amber, sorry about
Y'all are awesome.
They're incredible, just so good.
I'm not gonna get too heavy, I promise. Sloth Life and several others in the chat have consistently been asking how my mom was doing. So she ended up having some complications after surgery. I just got the news about her repeat MRI that all infarcts have cleared. So there is there's no sign of any of those 6 mini strokes. So very good news for Mom. Others may know that I did lose a very dear family member of mine. So I appreciate all the kind words and thoughts our way. And thank you so much for prayers for my mom, because that was super, super scary.
We're so sorry to hear that, Amber. I know we've talked a little bit offline as well, but a lot of people expressed a lot of support for you and prayers and good thoughts your direction. So.
And I'm most certainly thank you guys a lot for that. I think this chat and channel has been what's gotten me through a lot of the last couple of weeks. So you guys are absolutely incredible.
Yeah. If I can use you as an example really quickly, we have amazing people in chat all the time. But we also have people who are here who need just a bit of sanity away from the craziness of life and the pressures they're on, and they use this as a way to sort of either stay sane or blow off some steam or just connect with some friends when things are going rough. And when I heard the news, Amber, that you shared with us through Mod Chat and when we talked, I tried to get you to take time off, but instead you're like, nope, I'm going to be focused on the channel. And so, Amber, thank you. I know that at a time when you're going through a mourning, that when you focus on other people, it just shows that you're one of the good ones. You're amazing. Thank you for all you do. Appreciate
Thank you for that. Yeah. I appreciate that, Scott. Thank you. Thank you in chat. I see you all. I can't tag everybody. I'm sorry.
Thank you.
All right. I'm going to jump off now before I start the waterworks again. So love to everybody.
Thanks, Amber. We'll see you soon.
Not a problem. Bye.
Mackenzie Jabley gifted 5 memberships again. There's 1, 2, 3, 4, 5. They're flying. They're flying through. Holy cow! All right. Tony Schaefer, member for 24 months. Woohoo. Pink also, and I agree with everyone. Mrs. Ari needs to be a feature now. Love the cooking show. She's amazing. She is absolutely amazing. She is organizing our house right now, like you would not believe. She's really good at doing organizational stuff. I am not, which you should not be surprised about, but I'm not a good organizer. Mods are the best. We have the best mods. Let's see. And news about Jules. I've not heard. She was on Trial TV Live. I've not heard anything since I last bumped into her there. She was on a live stream there. It was probably over a month ago. It's been about a month. There's a variety of cases she's following. Sometimes they don't match up with what we're following, so we don't always get to catch up. I don't know. If you hear anything, let me know, please. Loved your chef hat. I got that at Hobby Lobby in the paper. I don't know if every Hobby Lobby's laid out the same, but it's like walk all the way to the back and all the way to the left and come forward one row. That's where it was. I've got the apron there as well. She is such a good organizer. All right, let's see. Still on break here. The jury's going to use all the time they can here. Okay, you are the best button organizer I've ever known. I buy them pre-organized. Let's see. I had a lot of fun making those. We're gonna do salsa here soon. We'll definitely do salsa soon. Have 2 Grands ball games in an hour. Lori better talk fast. I've told you, I'm giving Lori an hour. She's got to be done before then. Most likely no verdict today. Lots of state closing. Looking at the time, let's see, what time is it?
In front of the Walmart.
Hey, Siri. What time is it? Come on. Siri, you know I'm talking to you. Hey, Siri, what time is it in Arizona right now?
In Phoenix, Arizona, it's 15:11.
Okay, so 3:11 for those of you that don't speak military time. And they usually don't go late. So if she goes an hour, that'll take her to 4:15, 4:30, depends on when we come back from the break. I don't know. It's a late start for deliberations, but I don't know how late. The jury might only need a few minutes. Give us the forms now. We're ready. Okay. Does Mrs. Ari think Lori's guilty apart from the throat punch? The throat punch did it. Deanne B., member for 19 months, says, I'm just here to hear Amber's laugh. We love you, Amber. Thank you. We need to come up with them at least once a week for a shopping trip. Next time I'm going to do a more... Those were the most expensive enchiladas I've ever made. And honestly, I couldn't taste the difference like, oh, this cheese tastes so much better because it's Tillamook. No, it's just cream cheese. Okay, I probably could have done Philadelphia or even Lowe's store brand and been fine. Katie Bug, the super chat says, 1 week from now, having right knee replaced. 4 months after my left knee was replaced. Any and all prayers appreciated. Thanks in advance. Katie Bug, that means that in about a month, you should be able to schedule maybe a half marathon, and you'll be great. You got new knees. You're going to do wonderful. But prayers for sure for Katie Bug and the knee replacement. It's always scary. It's always scary for any sort of surgery. Luckily, I know that the technology for knees is just, it's amazing what they can do with replacing knees. All right. Who needs knees, Gumby? You got to do the tomatillos. Okay, I didn't know what a tomatillo was. I went to the store. You didn't tell me that it looks like I don't know. It looks like a grape inside a gremlin shell is what it looks like. I don't know what to do with that. You definitely don't water them. I know that. Hey. You guys, Mrs. Ari, swap for a minute. I need to run and see how you're organizing. Watch you pick out the products. Mrs. Ari went to the store brands. You pushed her for the brand name stuff. It was all me, Barb. It was all me. I thought First of all, I didn't know how good Lori's enchiladas were. And I thought that maybe if I didn't pinch pennies on the ingredients, they might end up a little bit better. Turns out that we blew it away. So don't forget the state has rebuttal also. I'm not sure if I'll be able to stick around for that. Mrs. R.A. is going to organize all my stuff into non-existence. Just don't feed them after midnight. Let's see. Be right back. Need to delete my kiddo's YouTube history for the past 2 hours so this one video doesn't keep making him mad. You should always listen to Mrs. R.A. There's some good advice. Let's see. I don't think any quality ingredients would save Lori's enchiladas. Colby said they were nothing special. Tweety tweet, you missed the state. But don't worry, it was 2 hours of your life you probably already had given to this trial, because she just went over everything that happened in trial except for the enchiladas. Drianne says, I'm ready for this part. When it comes to making Mexican dishes, please consult your California peeps here. Just saying. Be more. I hear you. Our stores do not have the right food. Like, I can probably get some habaneros. Oh, we're coming back. Lisa Maple, OG, member for 23 months.
How long does it last?
Oh, they were just testing the mics. Lisa Maple, thank you. You keep me laughing. That's good. Oh, laughter today keeps the doctor away. She's saving the enchiladas for rebuttal. Kim Judd, they were good. The first ones were fantastic, like the cream cheese ones. So good. I'm like, this is just a great flavor. And then we had the second ones, and I said, I don't want to try any of the first ones again. I did. I ate them all. We ate all of them. The second ones, I like the heat, and the second ones had heat. It was so good. The state does have some rebuttal. Usually that's short, especially if they did a really lengthy open. So Emily D. Baker is in the house. Emily, welcome. I see purple hearts for you. It's good to have you here. We're just excited for this closing, for what Lori can possibly do. I don't see a way. I don't see a way for her to do anything that will help her case. It's too late to ask for a lawyer, but that's the only thing that she could have done, I think. Lots of purple hearts. That is awesome. Emily, good to have you here. Welcome. Welcome. Please feel welcome.
All right, please be seated. The jury is present. The defendant can proceed with her closing argument.
Buckle up. Is she going to flirt with the jury on closing, do you think? Is that going to be on your bingo? Hey. Hi, guys.
Ladies and gentlemen of the jury, the state of Arizona has the 100% burden of proving that I committed a crime, a grievous crime, conspiracy to commit premeditated murder of my husband, Charles Vallow. The state has the burden of proving to you that this event was not self-defense. In your jury instruction under the instruction, use of force and crime prevention, the last line reads, if the state fails to carry this burden, then you must find the defendant not guilty.
Good. Cite the law.
In the law, under your jury instruction titled Justification for Defense of a Third Party, the last line reads, if the state fails to carry this burden, you must find the defendant not guilty. Under your jury instruction titled Justification for Self-Defense, the last line reads, if the state fails to carry this burden, you must find the defendant not guilty. In your jury instruction, under presumption of innocence, it states, the law does not require the defendant to prove innocence. Every defendant is presumed by law to be innocent. Under the burden of proof, it explains, that the state's burden is this. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. If, on the other hand, you think there's a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. In Arizona, self-defense is defined as not being a crime. So let's look at what we've learned in this trial.
Let's do this. Check it off with me.
We learned that a shooting occurred and that 911 was called, that law enforcement was notified. We learned that fire, EMS, and Chandler police arrived at the scene. We learned that my brother, Alex Cox, came out of the house with his hands up as directed by 911 and was questioned by the police in the driveway. We learned that I came up with my daughter Tylee, and we were told to wait by the car until police would speak with us. We learned from Detective Inklin on the stand that we asked for Tylee's medication from the house for her panic attacks, but it was not given to her. We learned that eventually my brother Alex was taken in a police car to the Chandler Police Department uncuffed. We learned in this trial that my daughter Tylee and I were also taken to Chandler Police Department in a police van. We heard from Detective Inklin's testimony that her goal was to make small talk with us. And
The jury will determine what the testimony did or did not show. Go ahead.
that her goal was to make the small talk with us and all the way to the station so she could speak with us separately before we would talk about what actually happened. We learned that all three of us were separated and taken to 3 interview rooms, where we each told police of the events of the day, each from our own perspectives, and answered all questions asked of us. We saw snippets of that interview in the trial here. The state did not show you the entire interview. Most of my police interview is admitted, though, into evidence in this exhibit. It's number 286. And I would encourage you to watch that entire interview when you start your deliberations. It is important. It is important for you to determine for yourselves my demeanor and not listen to anyone else. You can see it with your own eyes and hear it with your own ears. We heard from several witnesses that because this event was almost 6 years ago, that their memories of the events and statements were probably better back then. Well, my police interview happened that very morning, and I told the police the events from my perspective at that time. It is admitted into evidence and will answer many of your questions. You did not see Tylee's interview, but we did learn from Detective Inklin that she did an interview that morning as well. You did not see Alex's interview, but we learned that Alex was interviewed that morning by Detective Moffett, the original case agent, whom we did not hear from in this trial. The state chose not to show you those interviews or let you listen to the 911 call.
The jury shall disregard that last statement. Okay, the jury can only consider what was admitted into evidence.
We knew that was going to happen.
We learned in this trial from Officer Kautheim's testimony that Alex was injured on the back of his head with a bump and, according to his testimony, a 1-inch laceration. We did not see those pictures documenting that injury as well. We learned in this trial that we did not know, the 3 of us, that our interviews were being recorded. We learned that Alex's phone was taken by police and put into an evidence bag, according to Detective Duncan, and that no digital copy of Alex's phone was taken by the Chandler Police Department, even though this is their normal protocol. We learned that Alex's phone was returned to him that same day with no further inquiries. We learned that after my interview and Tylee's interview that we were introduced to a victim's advocate and that gave us further instructions in another room where Tylee and I were reunited. We learned that soon after that, all three of us, Alex, Tylee, and myself, were taken in another van and dropped off back at our house. We learned that we were instructed at that time that we could not enter the house yet, that we were directed by law enforcement to take the rental car, since all three of our cars were inside the police tape. We were directed to return later in the afternoon when the scene was cleaned up. We learned in this trial that we did as directed and left the house in the rental car close to 12 p.m. We learned that we did not return to the house until contacted by Detective Inkland to return to the house so that Alex could walk the detectives through what they call a walkthrough. We learned that many detectives were present during that walkthrough with Alex. We learned that Detective Duncan was there, Detective Coons was there, Detective Moffett was there, Detective Werther was there, and an officer with a body cam was there. And yet, we were told by Detective Duncan, the case agent on this case on the stand, that because of some problem, the walkthrough was not recorded. Detective Duncan also informed us that he does not know if any of the people present wrote a report about it. We can infer from Detective Duncan's testimony and the fact that we don't have in evidence any body cam footage of the walkthrough and no reports talking about it, that there are none, even though this would be crucial evidence for you, the jury, to have.
Sustained, the jury should disregard that comment. Again, the jury can only consider evidence that was admitted into testimony. I'm sorry, testimony that was admitted into evidence or exhibits that were admitted into evidence.
Is 38 the right count now for the we learned?
The state of Arizona has the obligation to show you evidence to prove that this event was not self-defense, as stated by the only 3 witnesses. So why not show the jury all the evidence that they gathered?
Here's number 4.
Again, sustained. The jury can only consider the evidence and testimony that was admitted into evidence.
We learned in this trial that Alex fully cooperated with law enforcement. We learned that my daughter Tylee fully cooperated with law enforcement. We learned that I fully cooperated with law enforcement. We learned that law enforcement treated all of us that day kindly and courteously on July 11th, 2019. That law enforcement treated us that day like this was self-defense.
We fooled them.
We were not given instructions to stay in town. We were not given instructions that we were under investigation of any kind. On July 11th, 2019, we were interviewed by Chandler Police and released with no further instructions. We learned that Chandler Police put out a press release that day on July 11th.
Objection number 5.
I'll sustain that objection to the extent the jury is to determine what the facts did or did not establish.
Under Arizona law, I had the right to self-defense. Tylee had the right to self-defense. Alex had the right to self-defense.
Yes, but murder is not self-defense.
This event was not planned or expected. It was shocking. We learned in this trial that Chandler Police Department neglected to do a thorough investigation. We learned that they did not swab Alex's hands for gunpowder residue. We learned that they did not swab my hands for gunpowder residue. We learned that they did not swab Tylee's hands for gunpowder residue. We learned that they did not luminol the gun. We learned that they did not luminol the bat. They did not test the DNA on the bat that they collected. They did not test the floorboard. They did not test the projectile. They did not test my husband's shirt. They did not search the rental car. They did not search any of our 3 cars that were there at the scene. They did not test the gun until over 5 years later. The Chandler Police Department did treat this event just like it was self-defense and a tragic family event. We learned in this trial that Charles and I were obviously having marital problems. Regardless of what was happening in our marriage at the time,
Your problem.
On July 11th, this was self-defense.
Your problem was that he was your husband.
When Tylee came out with the bat to protect me, her mother, Charles did not have to take the bat from Tylee and start swinging. At 62 years old, Charles had a choice that day and could have put the bat down. A 2-minute period changed our lives forever. How are you supposed to choose between 3 people you love? Your husband, your daughter, your brother?
All right, hold on. All right, I'll caution the defendant not to testify about things that were not entered into evidence.
There it is, Emily. She's testifying.
How can you decide for another person if they feel threatened? Why does the state want to blame to someone?
It's a reasonable person standard, not the standard of the person.
I'm sure you'll point that out in rebuttal. I'll allow the argument as that inference. Go ahead.
Why does the state want to blame someone for this tragic event? What evidence did the state show you in this trial that I wanted harm to come to my husband? We learned in this trial that I was praying for my husband. We learned in this trial that even though my husband and I were having marital issues, that we were both trying to do the best things for our son with special needs, JJ. We learned in this trial that I was shocked.
You want to go there?
That Charles had changed his life insurance policy, but I was not angry as the state alleges. In the phone call we heard from the insurance company, we heard that I was disappointed for our children, our grown children, as well as our children still at home, but I was not angry. My husband Charles was providing for our children still at home. I had no motive to change that. We heard a lot in this trial about the Book of Mormon prophet named Nephi. This is the state's evidence to murder over self-defense, and it is utterly ridiculous. We heard from Detective Duncan, who admitted on the stand that he had no idea what I meant in the text message when I said, "We will be like Nephi." In Mormon culture, Nephi signifies strong faith, perseverance, and courage.
Right.
I think the judge should allow that.
Sustained.
The state's attempt to misconstrue the positive text message about a wonderful religious figure, Nephi, and try to turn it into an order to kill someone is absurd. This is an attempt by the state to try to retrofit a crime that doesn't exist. This event was not a crime. It was a tragedy. Don't let them turn my family tragedy into a crime. When I'm done speaking to you, the state gets to get up and rebut all that I've told you. They've got to have the last word, so to speak, because it is 100% their burden to prove to you that I committed a crime. And you won't be allowed to hear from me again. So I want you to remember that it is the state's job to prove to you that I committed a crime. And if you have not seen the evidence that leaves you firmly convinced that I have committed this very crime, then the state failed to show you the evidence that you need. Because I did not commit this crime. The only interview the state entered into evidence is mine. So I encourage you to go watch it. I told you just what happened that day, just the way it happened. The state put forth a bunch of evidence in this trial in an effort to make you dislike me, to try to attack my character, so that you would just say guilty no matter what evidence they showed you. But only you get to decide. The state put up witnesses that had zero knowledge of a conspiracy. The state did not show you evidence of an agreement to commit murder. They showed you evidence of a family tragedy, and then they showed you the sad effects of a family torn apart because of that tragedy. That's all.
That's all. That's your big finish.
All right. The state does have the burden, so I have the right to open and close the argument. Do you want to give a rebuttal close? Go ahead.
Keep it short, please. The jury's attention is...
The execution of Charles Vallow is not a family tragedy. There is nothing that you can say about shooting a man as he lay on the ground that you can try to construe in any way to make that a family tragedy. This case is about the defendant, not Alex Cox. Alex is involved in it because that is her co-conspirator. We are not here to determine his guilt,
or how he died,
albeit
or why.
it is quite obvious. This defendant wants you to just look at one piece, and she wants you to hope that there's only a person who will say, I saw, I heard the conspiracy. But what did you hear in every instruction is that you can look to other evidence to show that. This defendant wants you to forget about her words and pretend that when she told her lover, her soon-to-be husband, we got rid of him, that he changed the life insurance before we got rid of him, that somehow means what? That they killed him. And he changed his life insurance before they killed him. What does that tell you? That tells you motive, and that tells you who did it. This defendant is one of those we, because she's writing it. She wants you to pretend that when she is talking about Charles for months, acquiescing and agreeing to her brother killing him, having people tell her that it's wrong, having people know that they're planning for something, that those words don't mean exactly what they are. We got rid of him. This defendant. The state, of course, has the burden. And that's how it should be. But every one of those justification defenses falls short when you look at the conspiracy itself. When they got rid of him, they did it by planning it. There is no reason that Alex Cox came over to this defendant's house with a loaded gun and waited for Charles to come inside, held there by this defendant using the cell phone. That is conspiracy. That is planning. That is premeditated. You can absolutely watch that whole video. That's why the state included that for you. What you're going to see is that Lori Vallow doesn't cry. She is not truthful, as we've gone through. Her timeline is absolutely wrong. She tells the detectives it's quick, it's 12 minutes. She wants you to believe that the police could understand all of this that day. But what did you hear? Is that all the police could tell initially was that the timeline was off. And then they started learning that the physical evidence seemed to be showing that Charles was executed on the floor, but they needed to see if the medical examiner agreed with them 2 days later. And then they needed to pull all those iCloud accounts, phone records, and go through terabytes of data to bring forth these things that you have now learned and hold. They interviewed these people who learned of the defendant's religious beliefs, that she was exalted, that she was celestial being, that she didn't have to repent. Of course she thought she was Nephi. We learned that the physical evidence on Charles
Cameraman's
and at
getting
the
daring.
scene show us that he was executed. And every single one of those defenses that the defendant has asked you to look at, the state has met its burden. Because even if you somehow believe that Charles actually had that bat and it wasn't staged like the rest of the scene with the shoes and the lack of blood there, that second shot is not justified for self-defense, crime prevention, or third-party defense. Arizona law does not allow you to execute a man on the ground.
She needs to close with "we learned."
The defendant wants you to believe she was shocked
The defendant's
and surprised by this. And yet, she goes wandering around, goes to Burger King, Walgreens, drops off her kid, comes back and jokes about her neighbors. Not one action of a person shocked, surprised. She wants you to feel bad for her daughter, Tylee. You saw her there. You heard from the detectives. She's also not shocked, crying, upset, worried. And you saw Alex. Same demeanor. Why? They've had 47 minutes to work it all out. Go through Charles's phone, figure out what they're going to say. They've talked on the phone twice in this time period. This case relies upon all of the investigation that the police did. That day, when they knew that timeline was wrong, that day when they started to understand that the physical evidence at the scene was staged and wrong and didn't match what the defendant was saying, and then all of the evidence after that, culminating when this defendant told the man that she married later that she was having an affair with as many times as she wants to say Charles was my husband. She didn't want him as her husband. She wanted Chad Daybell. She wanted that life insurance policy, and yes, she was angry about it. And she said, we got rid of him. That is her confession to you. That is why she is guilty of conspiracy to commit first-degree murder.
And that
Thank you.
is what we learned in this trial.
All right.
Great
We have
rebuttal
Izzy
closing.
coming over. Izzy to be sworn in. All right, members of the jury, there are 14 of you, only 12 of you can deliberate. At this time, we're going to choose the alternate jurors by random lot here.
Laura's asking
So we
questions
have our
about this earlier
scientific
today.
method here of random numbers.
14.
Juror 14.
You're out.
5.
Juror 5. I don't think you're 5. Well, maybe you are. Okay, so
5 is like,
to the alternates, if I don't see you again, I want to thank you for participating in this process. The admonition still applies to you until we call you and tell you that it's been lifted. I have in the past had to have callback alternate jurors to testify or to deliberate when, for whatever reason, one of the jurors can't continue to deliberate, becomes sick, has a family emergency, etc. So you still could have to deliberate in this case. But again, if I don't see you again, I really do want to thank you for participating in this process. I know it might be somewhat of a disappointment to not deliberate right now, but we will keep you posted and we'll let you know if we need you. The remaining 12 jurors will retire to the jury room and begin your deliberations. First, we're going to swear in my staff.
Do you swear that you will take charge of this jury and protect their deliberations from all outside interference and communication, and when they have reached a verdict, you will bring them back into court without revealing the verdict to anyone, so help you God?
I do. Izzy, drop those off. Undrop those off.
So it's a little hard to time the timer because we are on a half-hour delay. So the jury's been deliberating for about half an
All
hour
right,
now.
to the jury.
Out. here. We'll keep monitoring here. It's interesting to hear what Lori said in her closing, where she said the state is trying to make me look like the bad person, the bad guy. They're trying to paint me in this bad light to make you hate me. I have to say that for the jury, they might see it that way, because the jury doesn't have any prior knowledge about Lori Vallow, any of her prior convictions, especially with her, with her children, that she was convicted of first-degree murder in their deaths, as well as 3 counts of conspiracy and the whole fraud thing, grand theft. They don't know that, but for those of us that watched this,
proceed with an aggravation phase of this trial. So I'll let the parties review that. It's not too long.
These are the instructions for aggravation phase. Whether they find that aggravation does exist, aggravating factors.
All right, we'll be at recess until we hear from the jury.
It's in the jury's hands now.
All right.
What I was saying with the comments there, when Lori got up and gave her open, for those of us that have followed her case and followed what she's been convicted of and is currently serving a life sentence for, she used the terms mother. And she was talking about her husband and and her children, about Tylee and JJ, talking about them as any other mother should. That's when I had a hard time liking her, because we know that she at one point believes that they had become dark and had them killed. Look in mod chat. I will look that right now. Hang on one second. Okay. Official deliberation clock started at 3:12 Pacific, 6:12 Eastern. So we're going basically, we're almost up to half an hour. And to have her then in the closing continue to play this card, and she's like, well, I'm the mother. I had to worry about my kids. And it's like, really? That didn't age very well, Lori. That didn't, you worried about your kids? Are you still worried about your kids? Anyway, a little frustrating. Verdict watch is here. I've told you I would give Lori an hour. She's done rebuttal. We stuck around for that. I don't know if anyone's doing a verdict watch that is following this. Do you guys know any of of your favorites out there who are running commentary or discussion about this during the verdict watch? Verdict's only a 5-minute delay, so as soon as it's announced, basically it'll be nearly live. Let's see. Have they? I don't think they've gone home. There's no way. Trail TV Live is okay. We can portal to Trail TV Live for verdict watch. Here's what I think is going to happen. First of all, the jury has to sort out the jury stuff. This is the first time they can sort of talk to each other about this trial. Yeah, they've been able to do small talk and, hey, how are the kids? And, hey, do we like some eggs? Everything else. They've been allowed to do that all along. But this is the first time to get to talk about this case, even though they've been sitting next to each other and standing next to each other in the hall, going to lunch together. They can finally say, wow, what did you guys think? It's going to take a minute. They're probably not just going to walk in there and like, all right, let's get a foreman, and where's those papers? It's probably not going to be that quick. And then if, for some reason, one of the jurors, or any number of the jurors, or all of them, says, this is a big case. I never expected to sit on a trial this big. Wow, I think we need to do it justice. Let's read the instructions again, make sure we get this right. And those take half an hour at least to read through, probably more. Judge did it very quickly because he speed read through them. And then we should probably watch the video. Lori Vallow's video. I'd like to hear it. What didn't we hear? So it could take some time. It's probably not going to be a verdict tonight. The jury went home. There we go. Long Crime says the jury went home. If I paid attention to chat, I would have known that about 5 minutes ago. No verdict tonight. That means that we most likely will have a verdict on Lori Vallow the same day we have openings in Karen Reed, because that happens tomorrow, which is, I imagine the jury, after all that today, just said, look, let us sleep on it. Let's sleep on it. We know what we have to do now. We know what works ahead of us. Let's just go home, start fresh, and have a full day. So tomorrow's going to be a fun day. We'll probably get to hear the updates about this while we're watching the Karen Reed trial. Probably, maybe, if they time it right, during lunch. That would be quite reasonable. Have the jury come in early and start deliberating, maybe. That would be good. To all those that are here, thank you. Thank you very much for being here. So there's no portal needed if there's no verdict watch going on tonight. So I'm gonna sever the portal ties. If you missed our live stream where we cooked green chili chicken enchiladas, which were better than Lori's, ours were called killer enchiladas with Mrs. R.A.'s signature throat punch, which is delicious. Please go back and watch it. It was delicious. It was a lot of fun to do that. That was Thursday night. We did that stream instead of the podcast because our regular partner was out of town. But go back and watch that. Let me know what you think if you do the recipe as well. I think they were killer. They were really good. How could you forget something like that? So, big case starting tomorrow, bright and early. Runkle has Andrea Burkhardt. Hey, maybe we can portal over to Runkle. Give me just 1 second. Let's see if he's got that up already. Let's see. I see it. I see Monday Law Fun Day. That's for April 21st. That's today at 8 p.m. That's in an hour. We can portal there. We'll do that. That'll give you something fun to watch tonight if you're still hankering for a little more court action, because it's pretty much all over. Most of the courts are done for the day after that. So we'll portal. Thanks for the idea. That was awesome. Haven't rated Runkle in a while, but we'll do that now. Portal, not in this trial. Oh, we're portaling. Grab your portal, buddy, and buckle up. So. Anything else we need to cover before we wrap up and get a good night's rest before we start Karen Reed tomorrow? Thank you to my wonderful mods. Absolutely amazing. Y'all are incredible. I could not do this without you. Thank you. Somebody grab my hands. Thanks, Tattletale Boys. Oh, Nate Eaton's good. He's always got a good stuff to cover. He did it. He's done it. Okay, he's done such a good job covering this Lori Vallow case from the beginning that he was listed as a witness. You can't get any better than that. It's amazing. Tomorrow, I don't know what time off the top of my head. I'll have to look at the schedule. But be here early. We're back on the East Coast. So it's an early start to trial. I'll wake up early. I promise we're not going to be late. Tonight, when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe. We'll go live again tomorrow morning with openings in the Karen Reed round 2. Cross my fingers. Round 2. There we go. It's gonna be interesting. I can't wait to see how the defense opens. I can't wait to see how the state opens. I want to see if the state has a different theory as to how things went down, as they have a little more time to sort of mull over the testimony they received and the evidence, and maybe have something that fits a little closer. Because to me, it didn't fit. And if the shoe doesn't fit, you must have quit, right? All right, when you portal over, like the stream for Runkle, that would be great, and he'll be starting in about an hour. So I think that's it. I wish I had some enchiladas to eat. I don't know. I've got to go see what Mrs. Ray threw out that I own that I can see if I can rescue before it goes in the garbage. You guys have a good night. We'll see you tomorrow. Bye-bye. Thank you, Josh. Great super chat. Appreciate you.